hours, 4 hours. So, Mr. David Russell, we were discussing among us yesterday that perhaps what you need to do is to reconvince us that the questions you put before us fall within, or rather what you are seeking for, as we were discussing in the room that day in the library of the IFC courts, we were discussing as to whether what you are seeking for is actually intended by that provision which you are relying. So, I know you cited in your submission the Canadian case, but that's about all that you have. But apart from that, is there anything else you want to say to persuade us that we can invoke that provision which you are referring to or which you are relying on?
Indeed, Your Honour. First, can I say there's another party who's supposed to be here, and that's the Family Business Council Gulf. I don't know what steps the registry has made to contact Mr. Hamade, who's appearing for them. I know it was very much his intention to be present because I spoke to his secretary yesterday, who was making the arrangements, but I must say I haven't seen any message from him here. Perhaps if somebody could make contact with him, because in a sense he's an important part of this, and who he represents is an important part of this.
Mr. Russell and Chief Justice, I'm so sorry to interject. It's the Deputy Registrar. We have made contact with Mr. Hamade's office. We can't get through to him.
No. Hello, good morning. I'm here on the phone. I'm here on the phone.
Fantastic. Thank you very much.
Yeah.
Mr. Hamade.
Yes, good morning.
Is that Mr. Hamade?
That's correct.
Okay, you are the author of the book that I received.
Yes, I'm afraid so.
Okay, great. No, yeah, okay, good. So yes, Mr. Russell, I started off by saying something just now.
Yes, certainly, Your Honour. There are, as Your Honour will recall from the correspondence, which starts with the first document in the hearing bundle, which is the letter to you from the DIFC authority. The statute is set out on page 1 of the hearing bundle, and then you have the reasons that have been put forward by the authority for seeking to invoke the jurisdiction of the court. There are, in a sense, two questions for the court, or well, there were two questions for you in the first instance in making the reference to the court, and then those questions now come before the court. The source of the inquiry or the request from the DIFC authority was as a result of the recommendations of the DIFC's authority Wealth Management Working Group and its recommendations. The report of the Wealth Management Working Group is part of Exhibit JJV1 to Mr. Visser's first witness statement, which is the fourth document in Section A of the hearing bundle. The result of the Wealth Management Working Group report was to identify a series of problems that had arisen for the authority in connection with the implementation of both the trust law and the foundations law. And essentially...
sorry to interject, David, but that is the reason why you're seeking this order or interpretation from us. But if you read the provision which you cited of the Judicial Article 5 of the bylaw of 12 of 34, it says the Court of Appeal shall have exclusive division to hear and determine appeals from blah, blah, blah. B, request the interpretation, the word is interpretation, by the Chief Justice of the courts of any article of the IFC court in the region upon application submitted to him by any IFC board, such interpretation shall have the same authority as the interpreted legislation. So it's the interpretation we are talking about. Okay, this Judge Robert, you want to say something on this before David, Mr. Russell proceeds on? Robert?
Mr. Russell, it's really a question of setting out, if you like, the general parameters within which we're operating in responding to these questions. And it seems to me there are two issues. The first issue is one, whether the question falls strictly within the jurisdiction conferred on the court, the advisory jurisdiction. And then the second question is, if it does, should the court in any event answer the question that is posed? And that's a matter of discretion, I think, as to whether it's appropriate to do so, particularly having regard to the apparently legislative effect of the court's answer. And I think that's a point which is raised by ADCO in their submissions. So it was my hope that we might just have a little threshold discussion about the parameters. The advisory jurisdiction is a jurisdiction involving interpretation of any article of the DIFC. And that, it seems to me, directs to the text of particular articles, and then the question whether there are more than one interpretation available on those articles, and which is the preferred interpretation. And that's a matter of construction. By reference to the standard rules, I would have thought of text, context, purpose, which I think we're all familiar with. By purpose there, of course, I mean the purpose of the legislation, not some desirable public policy floating out there, into which we might try to shoehorn interpretation. Then there is the question whether all of the issues which have been presented to us are really about interpretation. And I guess a question which has the form, does any provision of the trust law prevent this or that? Is that a question of interpretation of an article, or does it require a global view of the trust law? And I suppose thirdly, they're the jurisdictional questions, and the question is, are there issues which are better left to case-by-case determination with the, I'm not sure what the correct pronunciation is for a WAQF, is it WAQF?
WAQF.
Yeah. And there are questions relating universal application to WAQF, but it may be that there's a diversity amongst WAQFs, and one might need to look at the differences between different WAQFs before deciding whether they fit into a particular form of legislation. Similarly, with the execution of any orders made under the trust law. Now, ordinarily, you would think the general provisions for execution would relate to that, but may there be particular cases in which there might be an issue about whether an order made under the trust law is amenable to execution under the general procedural provisions. One wouldn't want to have an answer with a legislative effect, which in effect says everything is susceptible of execution, but there may be cases we've not thought of which aren't. So they're the sort of considerations I have going to jurisdiction and appropriateness.
Before you answer that, David, can I ask Judge Ali whether he has to say anything or to add before you respond to our questions? Judge Ali?
Yes, thank you. No, I just shared, the same concern you have just raised, and Justice French as well. It's the same my concern, that what type of threshold that Mr. Russell should go through today about whether making a real classic case of interpretation or step into trigger a wider policy presumption.
So, David, the floor is yours.
Yes. Indeed, and thank you. I thank the court for the question. This may be a problem for Justice French if he hasn't been able to access the most recent version of the bundle. But yesterday, four documents were added to the hearing bundle, one of which is document 13B, which is at pages 279C to 279E. And what that document sets out is the questions and the proposed for the court and the proposed answers. And one of those questions, as you'll have seen from submissions yesterday, is the parties wish the court to answer that in a slightly varied form. But if one goes then to the questions that are posed, and starting with the first one, it asks the question.
Mr. Russell, before you go on, I have a document called Questions and Revised Proposed Answers. Is that the document?
That's the document, Your Honour.
In hard copy. Thank you.
Your Honours will see, if one goes to the first question, that it asks what the word property that's referred to in Article 34(1)(d) of the Trust Law refers to when it refers to property. Now, Article 34(1)(d) of the Trust Law, you will find, let me turn it up in the bundle. It is document 21 in the hearing bundle in section B, and Article 34(1)(b) is on page not even the right section number.
Where do I look at this? Where do I look? I look at laws, other materials, cases, articles.
Laws. It's in section B, Your Honour.
Laws. Okay. And then I've got a list of laws here. Which one do I look at? Bahraini.
It's number 21, Your Honour. It's
number 21. Number 2, the IBC laws. Yeah, I got it.
And at page 713 of the hearing bundle, so it's in document 21.
Page what page of that legislation? 5 or 47?
It's
what
page 16 of the
16. Okay, 16 of the legislation. Okay, I'm waiting for it to download. It's coming.
I've got it in hard copy, Mr. Russell, and I noticed that the provision 34(1)(d) really sets out one of the necessary conditions for the creation of a trust. In other words, it's got to be property.
Yes, and Your Honour will see in that regard, and it's not merely section 34(1)(b). Your Honour will see that if one starts with section 33, I'm just trying to get a copy of the document that I sent you initially.
Creation of a trust.
Yes.
Creation, validity, modification of trust law.
Yeah. And the issue, because if Your Honours turn to Article 33, Your Honours will see that a trust is created in each of 4 instances by reference to property. Property, if one goes to 33(1)(e), transfer of property to another person. So that is a trust if one uses the conventional description created by deed of settlement. Article 33(1)(b) refers to a transfer of property from one trust to another. Section 33(1)(c) refers to a declaration by the owner of identifiable property that thereafter the owner will hold the property as trustee. So each of those sections, and I'm sorry, Your Honour, the question should have referred to the use of the term property in Article 33. The precise question which arises for the court is whether the word property on each of the three occasions where it occurs in Article 33 is a reference solely to property within the DIFC, or whether it is a reference to property anywhere in the world, effectively. And the answer that we would say the court should give, and I think it is common ground on the part of all of the parties, that the expression property in Article 33, on each of the occasions it is used, is a reference to property in the generic sense and is not limited to property in the DIFC. So that is the point of interpretation. The submissions which we would make is that the reference to property is not so limited. We would say that is a question strictly of interpretation of the article, and we would say, for reasons that appear later, that that is a question which it is important that the court should answer. So that is the question of interpretation that arises in relation to Article 33 1b, and I'm sorry that the reference in the question is to Article 34. That, I'm afraid, is an error which should not have been made. If we turn to
Mr. Russell, this was the point I had in mind in relation to 34.1d, which is the way the question is currently framed, or was framed.
Well, 34.1d also uses the term. It effectively. I'm sorry. I should not have. I misspoke myself when I said the question was an error. Of course, 34.1d picks up generically the expression property that has been used in Article 33. And the question, again, is the property limited to property within the DIFC, or is it property that can be anywhere in the world?
Problem is, I think, that I'm not sure whether this goes to the question of where the interpretation is located, but it struck me that the problem is that both 34 and 33 tell us only about the nature of a trust, how it may be created, and the requirements for its creation. And one of the requirements is property, obviously, and it's silent on where that property may be located. And to answer that question, wouldn't you have to know something about the scope and application of the Act? This isn't telling you that you can have property from anywhere else. It just tells you that if you're going to have a trust, you've got to have property. The question, can that property come from anywhere in the world or be located anywhere in the world, has to be answered by reference to the Act as a whole, doesn't it? Or to the scope and application of the Act, or to provisions other than 33 and 34?
If one were to ask that question, and it is addressed in our submissions, Your Honour will see that there is, in the application of the law, which is Article 3 of the law, there is a reference to the law applies in the jurisdiction of the Dubai International Financial Centre. So that is the only provision in the law that relates to application as such. We framed, as I say, our submissions address Article 3, but make the point that it is simply a standard provision which one finds in almost every DIFC law. So it seemed to us that the question of application in this context had to be answered by reference to Article 33 and Article 34 rather than by reference to Article 3.
Can I say something over this discussion? I understand the object of these questions that you're putting to us is to encourage people in UAE and Dubai to register their trust with us according to the English law. That's what the intention is, I understand. But I have a discussion with another lawyer recently about our wills, which are also registered with us. And the wills we have decided covers properties not only within UAE, but outside UAE as well. However, we are not sure. We cannot definitely say it applies to a property, say, in Singapore or India, because whether the will registered in the DIFC can be enforced in Singapore or India depends on the law of India and Singapore. And in that context, property is not just landed property. It can also include money in banks, which is regulated by the laws of the local bank. So when we say to people registering their wills with us, we put a caveat, a conditional advice that insofar as property outside Dubai, the IFC is concerned, you can register your will with us, but we don't guarantee that will be enforced by the country or the laws of the country where the property is located. So even if we answer your question, Mr. Russell, yes, you can register your wakaf or your trust in the IFC, and that applies to properties outside UAE, outside the IFC. We cannot guarantee or assure that trust, insofar as that property is concerned, is enforceable. If that's the case, then I go back to your original intention. You may be defeated. Your intention may be defeated by limitations, by the limitations which I had mentioned to you.
Your Honour will recall that when the question of extending the wills registry provisions to international wills or international property was under consideration, one of the lawyers to whom Your Honour spoke on the topic was me.
Good.
And precisely that point was made. Can I say, in the context of trusts, the answer to that question is given and was only given quite recently by the United Kingdom Supreme Court in a case of Akers and Samba, which is referred to in our submissions and is covered in the and the case itself is in the hearing bundle. I think it's the first of the cases in the hearing bundle.
The name again, please.
Akers,
I've come across it.
Akers, A-K-E-R-S. Akers, A-K-E-R-S, and Samba. It is in fact, it's document 45 in the bundle. It's the fourth of the cases listed under cases.
Okay, understood. I've taken that down. Thank you.
And
yes,
that was a case that involved property in Saudi Arabia, which of course is a country that doesn't have trusts. But the United Kingdom Supreme Court held, we would say correctly, and we would invite Your Honours to reach the same conclusion, that equity acts in personam. It's a personal obligation binding on the trustee. And if the trustee is within the jurisdiction of the court can give directions to the trustee as to the trustee's obligations, and the trustee will follow those directions. so that the short answer to the question is that English law, and we would submit DIFC law, recognises trusts in respect of property in non-trust jurisdictions, even if in the non-trust jurisdiction you wouldn't be able to directly enforce the trust, because what you secure is an order directing the trustee to act in accordance with the terms of the trust. So we would say that this is, strictly speaking, by defining property as we have suggested as property anywhere in the world and not property limited to the DIFC, one first of all has the question of interpretation specifically raised by the law. And second, we would say that there is authority elsewhere which addresses the question, addresses it directly, and it is authority that we would invite the court to follow.
Now, Mr. Russell, I suppose there are different forms that an answer to your question, question one, might take. One answer might say this Act, or the Trusts Law, applies to trusts over property located anywhere in the world. Now, that will be a positive statement given legislative effect by the advisory jurisdiction provisions. An alternative would be, and it may be that we could go no further than this in the interpretive exercise that we're asked to undertake, is that there is no limitation on the location of the property which may be the subject of a trust to be derived from Articles 33 or 34 or from the definition of property.
Yes, indeed, Your Honour, and perhaps that raises, His Honour the Chief Justice posed two questions to me, and I didn't really answer the first, for which I apologise, because the first of the questions was what my client, the DIFC authority, is seeking to achieve in these proceedings. And whilst, in a sense, it is to solve a perceived local problem, and that might well result in greater resort to the legal platforms which the DIFC offers, the principal objective of the DIFC authority in these proceedings is actually to obtain certainty because of the nature of the jurisdiction, because there isn't the body of precedent to which both Your Honour Justice French and Your Honour the Chief Justice referred, to obtain from this court guiding principles about these issues. And in one sense, that will come from a reasoned judgment of the court, even if the answers which the court gives are not quite those which we propose, because the result of the decision of the court will be that there will be an analysis by the court of the way in which the provisions operate and the way in which the court will address these issues, which gives the certainty that the local business community, more widely the community within the United Arab Emirates, and the profession are seeking through this application. But yes, Your Honour is quite right. Whichever of the answers that Your Honour has proposed would achieve the objective that that is sought certainly by this applicant, and it's obviously for the other submitters to make their own comments about the form of the answer, but either serves the purpose of the authority of obtaining certainty about the operation of the law, because to answer the question in either of the ways Your Honour Justice French has suggested would involve a reference obviously to authorities such as ACRES and SAMBA and the authorities to which it refers. It's really quite remarkable. The case itself was decided in 2017, and until then there was no decision at ultimate appellate level in any common law jurisdiction that we have been able to locate that sets the principle out in the way that we've proposed it should be set out. And that it's a useful example of another issue which His Honour the Chief Justice put in the context of the submissions we were asked to make to him in order to have the matter placed before the court, which is, one might have thought the answers to some of these questions were axiomatic. Your Honour will certainly, from his knowledge of common law trusts, think that in many cases. That the problem in this community is that this is a new jurisdiction still. It's a law, or it's a body, it's a concept without an attached body of precedent, and providing the answers provides certainty in a way that I mean, each of the lawyers appearing before Your Honours would no doubt say some of the answers to these questions are axiomatic, but would also say that our experience within the wider community is that it's not good enough for us to say that. The essential thing is that the court should do so.
Mr. Russell, Your Honour, if I may add, this is Fadi Hamadi. I attend this session today on behalf of the Family Business Council Gulf. And if I may, I'm a practitioner, the General Counsel of a family business, third generation family business in the region called Al Group. Have been over the past 11 years and have been in Dubai over the past 20 years, also having worked with other family businesses in Dubai. The challenge that we have here today is that we have an immediate problem with a deferred solution. The immediate problem is the lack of what we call impenetrable succession planning structures that will allow family businesses to transfer wealth without fear of fragmentation and ultimate demise, which the stats from around the world point to. The odds are stacked against the continuity of family businesses. We talk about percentages, 30% only make it to second generation, 12 to the third, and no more than 4% to the fourth generation. So these odds are real, and they are compounded in this part of the world by the fact that we have a plethora of different jurisdictions that are overlapping to solve almost sometimes the same question. I think the IFC has to be applauded for assuming a pioneering role in devising legislations like the trust and the foundation law as early as 2005. However, as Mr. Russell has pointed out, the challenge has been often the uncertainty around the application of these laws outside of the jurisdiction of the IFC, and also the overlap between them and some of the laws that are pertinent to many of these questions, namely regarding continuity of management and ownership outside of the IFC. Now, I think all the applicants in this hearing are aware of the fact that it is a bit challenging for the court to opine on these questions. We understand that. However, I personally see this as a historic opportunity for the Court of Appeal to assume a leadership role in a subject that is of prime and cardinal importance to the economy, not just of Dubai, but also to the economies of the region. Especially given that family businesses play an important role in not just economic stability, hiring a large percentage of the workforce in the region, but also in terms of social stability.
Mr. Habade, I don't want to interrupt you, but we sympathize with what you're facing. I mean, I understand that the objective of Dubai is to encourage family to continue retaining the property, and that is restricted by the Islamic law on wills and waqafs, and that is why you are seeking to establish the trust law, to rely on the trust law. But in interpreting the law, normally we have to interpret the law. You cannot look at your problem, and we are interpreting the law to solve your problem. That's not the way, unless we read the law as in what you call applying the golden rule, where the legislatures were drafting the law to overcome that problem. If we apply that principle, then we can say that, okay, the law is drafted for this purpose, and therefore it should be treated in such a way that it will overcome the law is meant to overcome. You know, so I understand what you're trying to say. I've read part of your book, halfway through your book, and I understand your sentiments over that. So, but I would like to invite Mr. Russell to. I take note of what you say, Mr. Hamade. Sorry to interrupt you as you are speaking. I take note of that, and I would like Mr. Russell to continue what you're saying, Mr. Russell.
Certainly, Your Honour.
Mr. Russell, Your Honour, I just want to land, if you don't mind, if you can just grant me 2 minutes to land on the point. So we fully understand, all the practitioners, the applicants, that whatever you decide will not create perfection in a situation that is far from perfection. What we're looking for here is some certainty, some guidance to courts outside of the ISC. We fully understand that if you interpret some of these questions in the manner that we so desire, courts outside of the ISC, namely Sharia courts in Dubai and elsewhere, may beg to differ. But also the workflows and the local, the recently created legislations in these jurisdictions are also nascent by nature. And there's a huge lack of precedence there, one should say. So I think the interpretive ruling that the court may issue today may play a significant role in alleviating the concerns of some of the applicants or the practitioners out there, and will also guide the courts outside of the IFC to what is right and what is wrong, namely regarding to the overlap, between the Sharia points and the DIFC trust and foundation laws.
Okay. Yes, thank you very much, Mr. Hamadi.
Thank you.
Your Honour, I think I've said everything I can about the question 1 and why we say it does involve in the very strict sense that Your Honour the Chief Justice invited us to approach the question. I think I've said everything that I can about question 1, and why we say that does involve a specific in the interpretation of a specific provision of the law. If I can turn to question 2.
Yes, thank you.
The foundations law is, I need to get my, the foundations law is
may hold property other than trust property.
Yes.
Whether in regard to the terms of Article 12.2, the foundations law,
yes.
The IFSC may hold property other than the property of the foundation as defined in the foundations law.
The foundations law is document 30 in the court bundle, and Article 12 of the foundations law is on page 661 of the bundle. It's page 6 of the foundations law in document 20.
Ayman, can you project that, please? Can you project it on the screen, Ayman? Ayman?
Hi, CJ. I've just sent you a direction to the page. Did you receive it on your side?
No. Okay, I got it.
Thank you.
That's for me, but for the others, they get the same thing.
It should go for everyone who has page direction switched on.
Okay.
Thank you, CJ.
6 of 42, did you say? What was it again? I got here 6 of 42, number 10, article or section 10.
Once again, it's the relevant article. The Foundations Law was amended, and once again, I have to apologise for this, Your Honour. The relevant article is in fact Article 10, and
yes.
It is specifically Articles 10.2 and 10.3 that will engage the court's attention. The submission by the DIFC authority is that Article 10.2, when it says a foundation has the capacity, rights and privileges of a natural person, is that includes the capacity to act as trustee, and that Article 10.3, which says the property of a foundation is not held by it upon trust for any other person, doesn't operate as a prohibition from acting as trustee for a person. This is one area, I think one of two areas in which the submitters before you are proposing different answers, because the Al-Tamimi submission is that and I apologise to my learned friend Mr. Dylan Malone SC if I am misstating the Al-Tamimi argument, but the Al-Tamimi proposition is that Article 10.3 has the effect that whilst a foundation may act as trustee of a purpose trust, it can't act as trustee of a trust for beneficiaries other than a purpose. Now, whichever of us is correct, in our respectful submission, that is clearly a question of interpretation and one falling squarely within the terms of the article which confers jurisdiction on the court to hear this application.
I guess you read, don't you, Article 10.3 with Article 28, which tells us what the property of a foundation shall consist of.
Indeed, and Your Honour has noted. I can see that Your Honour has read our submissions on the point, and we thank you very much, Your Honour. Yes, that's precisely the point. That property of a foundation is a defined term, and it comprehends the capital of the foundation, the amounts that are endowed upon it, but not amounts which the foundation holds as trustee. I'm obviously prepared to argue the specific question later, but at this stage, for the purposes of the Chief Justice's question, and indeed Your Honour's question, this is clearly a matter of interpretation, falling squarely within the terms of the article.
Mr. Russell, sorry, what you want? Was that you want to say, Robert?
Sorry, I was just going to. It's all right, Chief Justice. I'll hold my point. I'm just going to go on to how the foundation works in a way that distinguishes it from a trust in dealing with its property. It has obligations in relation to people called qualified recipients who don't have any right or interest in its property, and they are therefore distinguishable from beneficiaries of a trust who might be seen to have an equitable interest. So that in its activity as a foundation in relation to the property of a foundation, its role is not that of a trustee, as I understand it, vis-a-vis the people who benefit from it, who have rights and entitlements to payment, but not any interest. But that wouldn't, as I understand it, was the argument, that would not prevent the foundation from receiving something on trust or declaring a trust or being subject to equitable obligations as under a constructive trust if it entered into some transaction which went wrong and then it had to discharge some equitable obligations. So it's merely declaratory in relation to the function of a foundation in relation to its property as defined in Article 28.
Your Honour, with respect, has expressed the proposition far more lucidly than our submissions. But in any event, we would submit that whatever the correct answer is, this is plainly a matter of interpretation of the law.
Okay, in what you have just said, David, can you put in the form of an example, a case example, because I don't quite follow what you were trying to say just now. Can you give specific examples on what you're saying?
Well, yes, indeed, Your Honour. If one goes to what establishes a foundation under the Foundations Law, Your Honour will see that a foundation is brought into existence by a person going to the registrar, seeking to have the foundation registered and providing property to the foundation. And then the Foundations Law contains a series, the creation of a foundation is dealt with in Article 17 of the Foundations Law, which is on page 665 of the court bundle.
Yes.
And when that is done, and then a foundation operates in terms of two constitutional documents, a charter and bylaws. The provisions in relation to that is provided for in Article 18 of the Foundations Law at the bottom of page 665 of the bundle. Article 19 then goes on to prescribe what must be in the charter, and Article 20 then provides for a second type of constitutional document called bylaws, which are optional in the sense that if you include the matters in the charter that otherwise are required to be included in the bylaws, then you don't need bylaws. In order to deal with the question that in the context of trusts is a requirement for a valid trust, is that there should be a beneficiary or nowadays a purpose. In the context of foundations, in order to avoid, to use the English law expression, there being property which is bona vacantia, which would vest in the Crown because nobody owns it, the Foundations Law provides in Article 21 for the concept of a default recipient. And then the easiest way to think of a foundation is that it is like a company without shareholders.
Charitable company. And under our law is called a charitable company, company limited by guarantee. That it?
Yes, well, this is, it's not quite, because there is no one who has an obligation to contribute to the funds of the company if it goes bankrupt, which would be required in the context of a company limited by guarantee. But the council for which Article 22 provides is effectively the board of directors. Article 23 then provides for a guardian who, in the context of a trust, you might call a protector. And then one gets to the property of a foundation is dealt with starting at Article 27, when it talks about...
What's bothering me just now was when you're speaking about the foundation, you were speaking about or talking about foundation with and without beneficiaries. Is that what you said? Was that what you said?
A foundation, Chief Justice, doesn't have beneficiaries. What it has is what are called qualified recipients. And
Wakaf. It's equivalent to Wakaf.
Yes, they are like the people who may benefit under a Wakaf.
Unnamed beneficiaries.
Yeah.
They're open to everybody.
Yeah.
Anybody who's what I call earning less than a certain amount is eligible to claim under the, or rather not claim, seek for benefits under that particular foundation. Is that what you mean? A walk-up?
Well, the provision in the Foundations Law is Article 29,
29.
Yeah. If Your Honour were looking, Your Honour the Chief Justice was wanting to have a general summary of the jurisprudence of foundations, probably the best place to look is the document which is document 90 in the hearing bundle. It's an article by Professor Paolo Panico. It's specifically on the DIFC Foundations law. It's pages 3,289 to 3,303 of the bundle. But whilst it talks about the Foundations law, it puts it in the context of the general law of foundations. If I can briefly summarize, foundations in the sense of private foundations as opposed to public foundations became a feature of civil law countries, really in response to the absence of trusts, starting in Liechtenstein in 1926. And Professor Panico in that article traces the development of the foundation concept initially in civil law countries. They then expanded starting in 1990 to extend into common law countries, starting in the Cayman Islands, but now there are foundations.
I read it somewhere, maybe in Mr. Ahmadi's book. I read that. It's nothing new. I mean, I've seen that. Anyway, you don't have to go into detail. Ayman, can you just take note of this particular article? Just for our judgment, we'll take note of this. And okay, can you go on, Mr. Russell? Go on to the next point.
Well, I'll take
note of this. I'll take note of this for my judgment.
Yeah. I think, once again, I think Your Honours will be satisfied that what is involved in question 2 is, strictly speaking, a question of interpretation of an article of the law. Question 3 relates to the expression in Article 10 of the Trust Law, the reference to the principles of common law and entity. As I've already mentioned, the Trust Law itself is document 21 in the bundle. Article 10 you will find at page 703 of the bundle. And once again, the question of interpretation is what is meant by the expression common law of trusts and principles of equity. And the purpose of the question is to define what is meant in the reference to common law of trusts and principles of equity. Specifically, and this comes back to the point that Mr. Hamade made both in his book and eloquently this morning before Your Honours, is what is comprehended by that expression. We say, and our submission, and this is an area in which the submitters have a common position, that the starting point is that one would go to the common law of trusts and principles of equity as understood in England and Wales, but that because of this court, the nature of this court as an international commercial jurisdiction, the court is not limited to the decisions of courts in England and Wales, but can look to the great common law courts elsewhere in the world. I mean, to pick one example, one area, because Australia has made far more use of the trust as a commercial vehicle than most jurisdictions, where it tends to be used as a holding vehicle. Australia is the place where virtually anyone in the world would look to find decisions relating to what happens to trustees who become insolvent. And His Honour Justice French will recall that issue arriving before him in in another capacity over the years. There's a particular reason for asking that question. As appears when one looks at the history of the trust law, because it was being introduced into a jurisdiction which had no experience of trusts, the draftsman looked originally to not to English statutes because there aren't any, and our colleagues from Al Tamimi have very helpfully included in the bundle an article by Mr. Justice Briggs asking the question whether or not England needs a trust law in the sense of a comprehensive one, rather than individual statutes dealing with particular aspects of trusts. The DIFC chose to go to the United States and to the Uniform Trust Code, which is not a code in the sense that, say, the West Australian Criminal Code is, as considered in the case of Bank of England and Bagliano Brothers, but nonetheless is intended to be a reasonably comprehensive statement of the law of trusts. And precisely because it has that background, the question that is constantly arises, well, there's nothing like this in England and Wales. What is the court going to do with it? Is it something totally new and different, or is it simply a statement of principles that is generally understood within the broad framework of the principles of equity, which the court will deal with as and when matters come before it, in the same way as a court of equity in another common law jurisdiction. And again, to pick a work with which Your Honour Justice French will be familiar, we've referred in our submissions to the observations about the trust law in Ford and Lee's Principles of the Law of Trusts, which place it squarely within the what I would call the orthodox common law jurisprudence of trusts. So we would say it's very clear that what is involved in the question is a question of interpretation of a provision of the law, specifically Article 10, and that it is, well, for the reasons we will advance at a later point of time, it's appropriate that the court answer it, but in terms of the narrow question, does this fall squarely within the jurisdiction of the court? Our answer would be yes.
Just fast forwarding to the substance or the merits, because I see, of course, what you say about its characterisation as a question of interpretation. You're asking the question whether the reference in Article 10 to the common law includes the common law of trust and principles as understood under the law of England and Wales. Now, that seems to be a question as to whether they apply, as it were, of their own force or by virtue of the statute in the DIFC, or whether, so that there seems to be a sort of hidden premise there. An alternative view might be that the real question is whether the DIFC courts apply, that the common law applied by the DIFC courts is the common law as determined by those courts from time to time, which will, of course, draw heavily upon the common law of England and Wales and other common law jurisdictions. So in Australia, for example, we have what we call the common law of Australia, which, as you know, draws upon all sorts of sources, but is ultimately determined by the High Court in that country. In the DIFC, it seems to me the common law is ultimately determined by the decisions of, I suppose, the Court of Appeal if a contested question comes up, but it's not bound to apply, and that seems to be implicit in your submissions, the common law of England and Wales. It can draw upon them and no doubt would rely upon them. But when you say the common law applicable includes that, it may suggest the direct application, whereas in fact it's part of the common law which may be drawn upon by the court, I think.
Indeed, Your Honour, and that is the purpose of part B of the same question, to make it clear. There is an article by His Honour the Chief Justice's predecessor, in which he talks about the role of the court as an independent common law court, reaching its own conclusions about these questions with great assistance from the decisions of the other great common law courts. We've also included in our reasoning, in our submissions, a case from the Hong Kong Court of Final Appeal, in which the matter is dealt with following a change of sovereignty in Hong Kong, and how the Court of Final Appeal will now address matters which previously would have been determined by the Privy Council. And of course here one has, in addition, the operation of the waterfall, as it's called, in the law relating to the application of laws in the DIFC, which make the law of England and Wales the default law if all other things are, all other sources of law have been exhausted. So I
think that applies to all countries. Malaysia, Singapore, India. We develop our own laws, although we keep on calling it common laws. But basically, we are developing our own laws. Of course, as you rightly say, by default, we rely on English common law. But we look at laws from other countries as well. So, I mean, I don't disagree with you at all there. Thank you.
Thank you.
Please continue.
Yes, if I can turn to question 4, sorry. The provisions to which we refer you there are identical in the trust law and the foundations law. If I can take you to the provision in the trust law, Your Honours will find that Article 40.
Law, it is possible for the person other than national. Whether if the trust.
Your Honours will find that
it's possible for a person other than national, which is a national organization, placing the trust or foundation. No. Whether if the trust instrument or foundation charter contains irrevocable provision. Yeah, Mr. Russell, do you want to continue?
Your Honours will find the provision itself on page 717 of the bundle. The provision in the foundations law is word for word, so I won't take the court's attention to that as well. The specific issue of concern here arises in relation to national ownership laws. Your Honours will be familiar with the fact that over large parts of the United Arab Emirates, and for that matter, in other parts of the GCC jurisdictions, there are limitations as to who may own interests in certain types of property and in certain businesses. And normally they require either national ownership, in the sense of ownership by a national of the country concerned, or a national of another GCC country. So the issue of concern in jurisdictions in the jurisdictions outside the DIFC is whether or not property that is held by a trustee or which is property of a foundation can end up in the hands of a person who is not a qualified person in the sense of being a national of either the country concerned or another GCC country. The evident purpose we would submit of Articles 40, 11 and 12 and their counterparts in the foundation law is to say first that you can have something in the Charter and you can have something in the Declaration of Trust or the Deed of Settlement which say that only a national can be a beneficiary or a qualified recipient. But the concern is that that may not be good enough if there's also a power to vary the terms of the constitutional documents in the context of a foundation or the trust instrument in the context of a trust. And the purpose of these provisions is to make it clear that if you have something in a trust instrument or the foundation's constitutional documents that prohibit a person who's not a national from ever receiving any property, that can't be changed, because that enables, and we've given Your Honours a reference to the operating law of the DIFC, under which the Registrar of Companies is empowered to give certificates as to the operation of DIFC laws, which would enable the Registrar to say to, for example, the Dubai Lands Department, that nobody other than a UAE national could ever own property or ever come to own property that's part of the property of this foundation or the property of the trust. And he can say it with confidence because the effect of these articles is to make it very clear that only a national can ever get a benefit out of the trust or the foundation. So as to whether or not this is a question of interpretation of the provision, we would say it squarely is. When it comes to the needs, Mr. Hamade's book identifies national ownership issues as a key issue and a need to be able to give certainty to regulatory authorities that these structures can't be used as a means of avoiding national ownership restrictions. So there is a purpose to asking the question, but as to Your Honour's question, whether or not this falls within the terms of the jurisdiction of the court, we would say very clearly that the question involves an interpretation of those two articles, and accordingly is one that the court does have jurisdiction to answer.
Now, Mr. Russell, it may be that one would say that the answer that you're seeking to that question is a statement of the bleeding obvious in a sense. That's with no disrespect to the answer, having regard to the provisions of Articles 40 and 19. But the answer no might be true in pretty well all cases. However, what about the case, and this goes to the question whether an answer should be given, even though it is an interpretive issue. Yes. What about the case where you've got the foundation engaging in dealings or a trustee engaging in dealings which give rise to enforceable rights on the part of some third party who may not be a national? And again, I use the example, for example, you might have a constructive trust or some equitable obligation or right created in relation to whether it's the property of the foundation or trust property.
Your Honour, we would, well, as to the Your Honour's expression, Your Honour's reference to the answer being obvious in most cases, that unfortunately applies to a lot of these questions, but we've explained why we think nonetheless it's appropriate they be answered. The question, we would say the specific answer to the question that Your Honour has posed is that it asks whether a person may have an interest in the trust or foundation property or derive any benefit under the trust or foundation. Now, we would say that the example that Your Honour has given is a situation where the benefit is not derived under the trust, but because of commercial dealing. And the easiest example, of course, is the contract of sale. The purchaser under a contract of sale with a trustee obviously has an interest in the property, but we would say that is not having an interest in the trust or deriving a benefit under the trust or foundation. So we would say that the answer is correct, but if the court felt it necessary to qualify the answer in some way, to deal with something that in some way, for example, resulted in a constructive trust that the court would impose, then we would have no objection, but we think the answer that we've given is technically correct.
Yeah, sorry, go on.
Sorry, I suppose my concern is heightened by the legislative effect of our answers, and you might end up with people having a debate about the interpretation of our answer.
That is what I'm worried about. I think there are too many qualifications. The question that you posed in question 4 seems to be too simplified, because I am very sure if there's a case coming before us on this sort of question, there'll be a lot more qualifications, and that is why, among the reasons why I keep on telling you, it's difficult for me to just say yes or no to all these questions, because I don't know, I think that they're a bit oversimplified, because there's so many other circumstances that may crop up, may be argued, facts may be slightly different, and by us doing... Now, the question after that is, assuming somebody is interpreting our interpretation, we answer your questions, no, and then comes a case where a party doesn't agree with the interpretation that we give. Or what happens there? Can they challenge? Can they say, no, our case don't fall within that? Or can they say, oh, the interpretation given by the Court of Appeal in this case is wrong? There's so many. There can be a lot more complications within as a result of the answers that we give.
Well, Your Honour, in theory that's correct, but in our respectful submission, certainly in relation to question 4, that wouldn't be so. Having said that, to the extent the court, first of all, I suppose I should say that we've identified 2 sources of jurisdiction for the court here. One is Article 5B, but there's also a jurisdiction under the court law, which actually didn't involve the Chief Justice being bothered with the request. The DIFC authority actually has the right directly to approach the court, and nothing in Article 27 of the court law, which is set out in our initial submissions, gives the answer legislative effect. So if the court were concerned about the legislative effect part of the judicial authority law, it could answer the question in terms of Article 27 of the court law, and one would imagine that a decision under Article 27 of the court law had the same precedential effect as any other decision of the court. In other words, open to review by the court at a later point of time. We would have said actually that a decision of the court, even under the judicial authority law, nonetheless is a decision of the court, and the court is permitted to depart from its precedents, its previous decisions. So we don't see the problem that we don't see it as a problem that if a matter is brought before the court that requires some qualification of the answer in future because of its specific facts, that the court would be precluded from doing that. But as I say, in relation to question 4 itself, we do submit that that's capable of an unqualified answer because of the limitations in the question itself. Can I go to question 5?
Yes, please.
Question 5.
Judge Ali, any questions on any question you want to put to Mr. Russell? Otherwise, we go on to question 5.
No, not really. He may go, and I'm satisfied with what happened so far.
Okay. Yeah. Question 5, please.
Question 5, and once again, this will be Article 57, which is on page 724 of the bundle, addresses the question of advisory trustees. It's a provision with which Your Honour, Justice French will be familiar because it's in the West Australian Trustee Act. But in fact, it originally comes from New Zealand. And the concern that would arise is that the normal rule is that a trustee can't delegate. The normal rule of English trust law is that a trustee can't delegate functions. And the consequence is that a trustee who, in effect, said, on this issue, I'm handing the matter over to somebody else, would be open to criticism by the court for having done that, because the court would say, well, you're the trustee and it's your job to do it. Article 57, as I say, I've given you its history, but the purpose of Article 57 is to say that a trustee may act on the advice of the advisory trustee, and if he does so, he will be discharged from his responsibility to make a personal decision. The terms of the provision itself, we would say, are perfectly plain, and again, we could be open to criticism for having suggested that the court is being asked to answer a question to which the answer is obvious in the first place. The significance of the question in the context of the environment here in the DIFC is that very frequently there will be a desire on the part of settlors in the context of a trust, or founders in the context of a foundation, to comply with their obligations under Sharia. And the easy way to do that, rather than expect them to have a trustee who is suitably qualified in the area, is to establish a Sharia board who will be a source of advice to the trustee. And that is the model actually that's adopted by the Financial Services Administrator, the DFSA, that they are not a Sharia regulator in the sense that the DFSA will not review what an Islamic finance vehicle is doing to ensure it's Sharia compliant. What instead they review is its Sharia compliance systems to ensure that that they have taken appropriate steps to ascertain their Sharia obligations and acted upon them. And in the present context, what Article 57 would allow a trustee to do is or allow a settlor to do by providing for a Sharia board in the context of the deed of settlement of the trust, is to enable the trustee to defer Sharia obligations to a suitably qualified advisor without incurring criticism from the court that they delegated their functions. So once again, although the question may seem one that has an obvious answer, there is an importance within this jurisdiction to have that answer. And in terms of the jurisdiction of the court, the question is clearly one related to interpretation of the relevant legislation.
In Malaysia, we have this law allowing the central bank and all the other banks to establish their own Sharia council. It's called the Sharia Advisory Council, and they will advise on matters relating to Sharia, the different types of products that the bank gives, and then that goes to the Sharia. And I believe it includes also questions relating to trust, because the bank is to some extent trustees as well. Mm-hmm. So it's nothing new. But the question here that you pose is, can the trustee rely on advice? I don't think any problem there, because if the trustee can seek the advice of his lawyers, why can't the trustee seek the advice of the advisory an expert in this particular field? That's my view.
Well, we would, with respect, very much agree with what Your Honour has said. The point perhaps is this, that first, a trustee doesn't get a discharge from acting on the advice of lawyers if the lawyers are wrong.
Very true.
The second is that in Malaysia, one of the attractions of Malaysia as a jurisdiction for Islamic finance is the existence of that central Sharia board and the capacity to get binding rulings. And one of the other recommendations of the Wealth Management Review actually was the establishment of such a board within the United Arab Emirates. We don't have one yet, and hence the proposal or the facility that we see this article providing to enable a trustee who is particularly one who has accepted appointment as trustee at the request of someone who wishes their affairs or the affairs of the trust to be conducted in a Sharia compliant way, to do that.
So when you said just now that the trustee's responsibility or liability remains notwithstanding what his lawyer advised, what are you saying in the context of this Sharia advisor? Are you saying that as far as if the trustee relies on the Sharia's advisor's advice or opinion, then he is to be protected? Is that what you want?
Yes, that in our respectful submission is what Article 57.3c provides.
Okay. Mr. Russell, one observation you made was, I thought you said something about the trustee being relieved from having to make a personal decision. It seems to me that Article 57 contemplates the trustee always making the decision, but in doing so, he can act on the advice of a person, which might include a Sharia advisor. And if he does, then he's protected to the extent that 57.3c provides. So presumably, he would have to act within the framework of the trust obligations generally, but in the exercise of discretion, could have regard to that or act upon that advice. But ultimately, it is the trustee's decision, isn't it?
Yes, indeed, Your Honour.
Yeah.
Okay. Can we? You want to go to question 6?
Yes. This relates to a different issue, which arises under first of all, the law relating to the application of DIFC laws. That Your Honours will find the law on the application of DIFC laws. It's Law 19 in Part B of the bundle.
Law 19. Ayman, Law 19?
Yeah. And it's Article 17, it's on page 652 of the bundle.
652 of the bundle. 652 of the bundle. 652, yes.
Well, Mr. Russell, why didn't you, refer Chief Justice to the article abstract in your submission, which is easy for him to follow, so he can see the question, he can see. Most of the articles you keep giving reference to are really copy-paste in your submission, so they always can be found in your submission, which is easy reference, I guess.
Yeah, that's the other way of doing it.
I'm happy whichever way is
yes, yeah, whichever way.
Okay. Well, in any event,
just continue. I'm quite familiar with this. Just trying to refresh my knowledge of. Just go on.
And the question of the purpose of question 6, and we ask it in 3 levels, is what is the interaction with Okaf, to use the Arabic plural, if they want to come into the DIFC. There's an article, or there are 2 articles generally about the way in which the jurisprudence of Okaf and the jurisprudence of trusts interact in the bundle. They are respectively an article by, I'll give Your Honours the reference, first an article by Paul Stibbard and others, which is Article 91 in the bundle, starting at page 3304. I apologise in advance. I was one of the co-authors of that article, and I know one shouldn't quote one's own articles in submissions to the court, but on the relevant parts of it, probably more written by Mr. Stibbard than me. The other is an article by Monica Gaudiosi, which is Article 80 in the bundle. I won't take Your Honours to them, but in broad terms, what comes from those articles, which is something I always find amusing here when people say, well, trusts are something foreign and come from, are matters that are, exotic to the region, when in fact one reads through Islamic history. On one view of the matter, the first trustee was the Prophet himself, and on another view it was the Caliph Omar. And the Gaudiosi article traces how the concepts came through, and she argues, in fact, influenced the structure of the first recorded English trust, which was the Trust for Merton College and the University of Oxford. The Stibbard article is far more just a comparison, but in short terms, a waqf which finds its current expression in laws in the Emirates of Sharjah, Dubai, and at federal level here, is essentially the same as a foundation. And the other document that you have, which is not referred to in any of the submissions, is a review of the DIFC's wealth management report from the DIFC's Sharia experts. That document is at, it's in part C of the material. It is document 41. It's a Sharia opinion, and it places the trust and foundations within the overall framework of the Islamic concepts of waqf and comparable arrangements for wealth management. Effectively, the difference between a waqf and a trust, as indeed is the case under the foundations law, is that a waqf has always in Islamic jurisprudence been treated as a legal person. In every other respect, it is almost identical with a trust. I mean, it has somebody who sets it up called a waqif, who we would call a settlor or a founder. It has an administrator called a mutawali, who in terms of trust law we would call the trustee. In terms of foundations law we would call the council. It has a supervisor called a qadi or judge, and of course that's the role played by the court in either the trust law or the foundations law. So they're extraordinarily similar. And what Article 6 seeks to do is to ask the question how these entities or arrangements can be part of or interact with the laws of the DIFC.
My answer is very simple. My answer is register the waqf as a foundation.
Well, Your Honour, the Chief Justice has Your Honour, the Chief Justice has anticipated me. That's precisely what we have said in the answer to 6B.
Once it's registered as what you call as a foundation, then you don't need this question anymore.
Well, the question.
Otherwise, we have to recognize an unregistered foundation as a foundation.
Well, no,
because if you don't register the Waqf, it's not a registered foundation.
Your Honour,
we recognize an unregistered foundation?
Your Honour, if I might direct Your Honour to well, first of all, Your Honour, we have said that if it has legal personality, then of course it's not a trust, because that's fundamental to the law of trusts, and that's our 6A. If in its place of establishment it doesn't have legal personality, then we say it could be recognised as a trust. Foundations can be dealt with in one of two ways under the foundation. Sort of foreign foundations can be dealt with in one of two ways under the foundations law. They can either be recognised or they can be continued. And questions B and C address those two alternatives. What happens? A foundation may simply wish, because it's at the moment, if a body is incorporated and wants to come into the DIFC, unless it is registered by the Registrar of Companies, it can't come here and it can't do business. It's prohibited from doing so by the operating law. But foreign companies, of course, can come here and do, I mean, starting with all the banks. And that's a process of recognition. And Article 62 provides that foreign foundations can be recognised by the Registrar of Companies. And if he does recognise them, then and register them, then they can come here and do business. Question 6C deals with the question, what happens if you have a Waqf that wants to come here and discontinue its operations outside the DIFC? And that's the process of continuation. The difference is that if it is recognised, then its corporate personality continues outside the DIFC and in its place of incorporation. Whereas if it's a requirement of continuation is that it forego its existing registration or incorporation in its place of establishment and solely has corporate existence within the DIFC. And the question, in a sense, is whether it's open to the Registrar of Companies if a Waqf turns up and seeks either recognition or continuation, whether it is open for him to do so. And our proposed answers to those questions are yes, it can. But in terms of the jurisdiction of the court, we would say the answer is that one turns to specific articles of the Foundations Law, and therefore what the court is doing, if it answers the questions as we propose, is engaging in an exercise of interpretation of the law.
Mr. Russell, do we know about the common characteristics of Waqfs to say that it is, to give an answer in effect saying that any Waqf from anywhere can be, if it has legal personality, be recognised as a foundation, and if it doesn't, be recognised as a trust? In other words,
effectively, yes. Your Honour will see that there's some discussion between ourselves and Al-Tamimi in relation to questions 6B and C, which Al-Tamimi have suggested the court might prefer not to answer. And Your Honour will see in the document headed questions and revised proposed answers. Your Honour will see that we have the suggestion for the proviso is ours, not that of Al-Tamimi. And if that proviso were added to the answer, and we would have no objection if the court thought it appropriate, the answer immediately, the prospect of it, as it were, of a Waqf that the DIFC doesn't want to come in here, getting automatic registration, disappears. So we would say again, no issue as to jurisdiction. As to desirability of answer, in our submissions, the point that is made by this and the answer to question 7 is to just emphasise once again that there is nothing particularly extraordinary about the DIFC's jurisdiction and laws in these matters. This becomes relevant too in the public policy discussion on which we've put in supplementary submissions.
Yes.
Okay. Paragraph 8, question 8, turns to the operation of the trust law, and in particular its interaction with an international convention called the Hague Convention. The Hague Convention for the Recognition of Trusts has been included with our material. It is document 28 in the bundle of laws. And that's an international convention which provides that trusts established in one jurisdiction can be recognised in other jurisdictions. In that sense, it doesn't take the common law much further, but it is significant in the sense that a number of civil law countries are also parties to the Hague Convention, including the Netherlands and Switzerland now. The purpose, and you'll have seen, quite apart from the provisions of the trust law, in addition to Article 17 of the law law relating to the law relating to the application of DIFC laws. There is provision in Article 96 of the DIFC trust law for the recognition of foreign trusts, which specifically refers to the Hague Convention. So a foreign trust that comes into the DIFC will be recognised automatically under the trust law. And the issue that is posed by question 8 is what happens to a DIFC trust if it moves elsewhere or seeks to be recognised elsewhere. Now, we're conscious of the fact that it's not open to this court to interpret the Hague Convention, nor indeed the laws of other countries that might relate to the recognition of trusts. So the question is limited specifically to whether or not there is anything in the trust law which would prevent a DIFC trust being recognised in a foreign jurisdiction for the purposes of those laws.
Mr. Russell, I don't think that's fair to put the question to us, The course of that particular jurisdiction, we have to decide whether it's going to recognize or not for us to tell them to recognize.
Yeah. Well, Your Honour, it's precisely for that reason that we have formulated the answer in the way, or formulated the question in the way we have. In other words, is there anything in the trust law which would prevent a DIFC trust from being recognised elsewhere? I mean, my answer
is I do not know the answer. Go and ask the judges of that jurisdiction. I cannot answer, and I don't think we should answer this. We do not know. It's not for us to say whether it's recognized by Singapore or by Malaysia or India. So well, it's not a fair question to us. I don't know what the other judges have to say, but that's my view.
The Al-Tamimi suggestion is the one that is the additional words in the document headed questions and revised proposed answers. There's certainly there is no suggestion on the part of the applicant that the court should seek to make a decision in relation to what will happen in another jurisdiction. It may be that the question could be rephrased or the answer could be qualified, but the point that is being sought to be made is that so far as once the DIFC trust is established, there is nothing in the DIFC which says, or nothing in DIFC law which says it's inappropriate for it to be recognised outside the DIFC. It's self-evidently the case that as a matter of sovereignty, any country can say we won't recognise the DIFC trust. The other point is that the Hague Convention is an open convention. The United Arab Emirates is not a party to it, although one of the recommendations of the Wealth Management Review was that it should be recognized, that it should be recognized, that it should seek to accede to the Hague Convention. But it isn't necessary in order to engage the Hague Convention that you be a convention country. So that, for example, if one were to take the United Kingdom as an example, there's no doubt whatever that a DIFC trust would be recognised, both as a matter of common law and under their local version of the Hague Convention.
Yeah.
So in our respectful submission, with the subject to a summary formulation of the proposed answer, in our respectful submission, it does what is asked of the court is whether or not there are local provisions. When I say local in the sense of DIFC law provisions, which make it impossible for a DIFC trust to be recognised outside the DIFC. Obviously, whether or not the laws of another jurisdiction have that effect are matters for it. And again, we'd submit it's a fairly important issue. And within, for example, this region, there are laws for the recognition of trusts. The Abu Dhabi Global Market Trust Special Provisions Regulations, to which we've referred, Your Honour, provide for the recognition of non-ADGM trusts. So does the Bahraini Trust Law. So do the Qatar Financial Centre Trust Regulations. So it is important in our respectful submission that it be made clear that the DIFC trust is intended to be an international jurisdiction. As Al-Tamimi have put it, DIFC trusts are part of the family of common law jurisdiction trusts.
You don't the law of another jurisdiction might seize upon, especially the way that political framework and ideologies are going these days. You might let's imagine an extreme example, perhaps, but some country takes objection to recognising any trust where a trustee is protected when acting upon the advice of a Sharia advisor. In other words, it's foreign law seizes upon some characteristic which is actually to be found on a proper interpretation, as you would put it, in our trust law. We just don't know what they might seize upon as a basis for non-recognition. I mean, most countries, as you rightly say, particularly those who accede to the Hague Convention and so forth, wouldn't have any difficulties, but there may be, we just don't know what the outliers are, I suppose.
Yes. Well, perhaps the way in which the question is asked invites the qualification that Your Honour has put, in the sense that you might well say that it's in fact Article 57 of the trust law, coupled with the recognition that's given to a possible Sharia advisor, that would prevent recognition of the DIFC trusts under under the laws of a foreign jurisdiction. And perhaps in that sense, the formulation of the answer proposed by Al-Tamimi is preferable, because that would certainly not involve the problem that Your Honour has identified.
Yeah, the problem is it's not really an interpretive answer, is it?
Well, well, then if one wanted to be strict, I would come back and say that what prevents recognition is not a provision of the trust law, but the domestic law of a foreign country.
Yes. Okay. You want to go to the next question?
That's question 9, and once again, the result of this, if one goes to the document headed questions and revised proposed answers, you'll see that it is, and this formulation, I must give credit to our colleagues at Al Tamimi for, suggested, have come up with this formulation. Once again, the purpose is not to ask the court to interpret Article 361 of the Law of Personal Status, which you'll see from the submissions that we've made is not, at least in the Arabic translation the English translation that's available, a particularly happily worded article. But again, it asks the question whether or not the transfer of a property under the trust law necessarily engages that provision. So it is a question of what is the effect of a transfer under the trust law or the foundations law. And under the trust law or the foundations law, what happens is that the laws of that property is transferred, either the whole of the interest, if it's a transfer under the foundations law, or at the very least the beneficial interest if it's a declaration of trust, or the full interest if it proceeds by way of deed of settlement. We've given the court, in terms of confidence in the answer, we've given the court copies of the National Endowments Law, which is the Waqf provision, and I'm instructed that in the actual law, the actual Arabic versions of the law, that the word Waqf is actually used. So you have the Waqf laws in each of Sharjah, Dubai, and nationally. One of the most interesting developments, and one that's not covered in any of the submissions because it has only become available very recently, is the federal government is proposing to implement a new trust law. And we have given the court in the bundle, it appears as one of the last laws, I think. Yes, Your Honours have, as documents 15A and 15B in the bundle, the Arabic and English versions of the current draft of the federal trust law. Now, we would simply say that when you have that range of local legislation to which you can add legislation in Bahrain, legislation in the Abu Dhabi global market, you can have confidence that there is no necessary conflict with Sharia because of the legal arrangements that occur under the trust law or the foundations law. But the point that we would make is, once again, what the court is being asked to do is to analyse the nature of the transfer of property, either a beneficial interest or a legal interest, and that of itself doesn't engage Article 361. So that is the basis on which we would say, and of course the other point is that Article 361 doesn't apply to non-Muslims who are a substantial part of the population of the United Arab Emirates. But then the discussion at greater length deals with those issues, but the specific point that we would make is that that the essential nature of a trust or a foundation is not one that produces a conflict with provisions that are there to protect Sharia obligations. And the basis on which we invite the court to reach that conclusion with confidence is now the very extensive volume of legislation and proposed legislation dealing with these issues at national, GCC and emirate level.
Well, Mr.
If I may add to what Mr. Russell has said, this is Fadi Hamadi. On the subject of Article 361 of the UAE Person Status Law, it's one of the most ambiguous articles, and even reading the interpretive memo of that particular law would not help really to shed light on the intention of the legislator. However, read strictly, the article sort of implies that any transfer by way of sale, grant, or will that is intended to be fraudulent to the interest of the future heirs should be declared null and void. So there's an element of fraud there that needs to be assessed by the court. Abu Dhabi Court of Appeal last year has ruled out that a particular transfer was fraudulent on this basis of an asset by a deceased person. I think what we're asking here for is to make sure that as far as the trust law and the foundation law are concerned, they're not put in the same pocket as sale and grant and will, just as much as the waqf in particular has not been mentioned in the article. I think it's befitting to clarify this to potential interested people or interested families, that just as the waqf law has not been mentioned in this article explicitly, trust and foundations are not by their own structure, should not be considered as fraudulent and as violating the particular provisions of Article 361. I think that kind of clarity will go a long way in appeasing some of the concerns around these articles and this article and the trust and the foundation laws in the IFC. Thank you.
Thank you.
Well, Chief Justice, if you may allow me.
Yes, please.
Well, first of all, I wonder if Mr. Fadi Hamadi is a Muslim scholar or not. I'm not sure really about the origin. It might not be very necessary even to know that. But the principle of protecting what called a will or inheritance in Islam is a very important principle and known to even a basic Muslim that who don't have a deep knowledge of the Sharia. It's meant to protect the economy, it means to protect the innocent people, it means to protect the soft movement of the wealth into the right inheritance and a lot of that. And this Article 361 of its nature, I think it's a very general and broad meaning article. Even if it does not exist in that law, even if it does not exist, because it talks about someone try to avoid the natural way of doing things. It's like, it's not necessary. And I have also problematic things about the interpretation of the wording. In your quote, Mr. Russell, to Article 361, it said, shall be considered void every fraud. I think having the privilege of reading the text in Arabic, it doesn't just talk about a fraud. It goes even to more than that. Any way of attempts to avoid the right application of the attempt, to avoid the right movement of the inheritance. So that would trigger, any person of any benefit that who have the doubt of this movement of the assets happened to confiscate or to take over his right, so he would go to the nearest authority where the jurisdiction is allocated and would complain about. And this is natural. This is not just about what, even if it starts with the foundation. Anyone going to feel or complain about suspicious transfer of assets or shares or anything would go and complain about it. And this is a general right given to any person in earth to complain about anything that he think goes against his protected legal rights. I mean, whether this 361 is there or is not there, I think it's always open to any person to apply to the proper court of jurisdiction that a certain legal right was done in a way to avoid the exact right movement of right. So I don't know what's the basis of bringing this, because you just try to remove the protection from a protection that's given by the general law to every single person to keep or to reserve his right, his future right, or whatsoever.
Judge Ali, the interpretation in English, is it correct, Lily, or you think it's not accurate? From Arabic to English?
Well, it's not really too far. I think in Arabic it's much wider because it talks about any kind of attempt to avoid doing things in a certain. The word called
not necessary fraud.
Yeah, it's
not necessary fraud in the context of English common law.
Exactly. Tahayyul is something different than ihtiyal. Ihtiyal is, it's ihtiyal, another word, is defined clearly in the UAE laws, UAE criminal laws. But tahayyul is, it's like when you're dealing with a tax. If someone, tax fraud and tax avoidance. See, this is exactly the difference by that word. Tax avoidance, when you might look like, doing, let's say, a legitimate transaction at the face of it. But after very deep investigation, it might look like, it's a tricky, sneaky way of doing things. So this is the real difference between the two wording. But in my opinion, Mr. Russell, this is a very general concept of protecting people rights. And I don't know why this questions comes to the.
And
if I respond to my learned friend, this is Fadi Hamadi again, I would agree that the word in Arabic is not fraud. Tahayyul should be interpreted as circumventing rather than defraud. But however, reading the interpretive memo, I don't know whether my learned friend has read the interpretive memo of Article 361. There's no assumption that a mere transfer of assets during the lifetime of the person should be considered as circumventing. The interpretive memo clearly regards a sham transfer as being a violation of 361. So there's no blanket ban on transfer or grant. And really the concern here is that because I understand that, the concerns of my learned friend, but there's a lot of misconception out there outside of DIFC that trust by its own origin is a violation of Islamic Sharia. Now, whether this is correct or not, it is beside the point, but there's a perception and understanding that I've heard from many learned people here in this jurisdiction that a trust by its own existence is not Sharia compliant, and such it should be perceived as sham. So the precision that we're seeking from court here is to say no, that it should not in its own existence should be perceived as sham just because a settler has decided in his lifetime outside of the death sickness to transfer assets even outside of what Sharia states or the Fara'id states. This should not in its own right be considered as a violation of 361 from the trust perspective, not from any other foundation, not from any other perspective. Thank you.
Who's that speaking? Mr. Hamadi, is it? Was it?
Yes.
Mr. Hamadi speaking. You started by saying violation of Islamic Sharia. Is that right?
Yes.
Did you say that, or I misheard you? Hello?
Yes, I can hear you.
You said that. Yes. You said that. Hello?
Yes, sir. Yes, hello.
But I thought we all been discussing that trust is within Sharia. That's why you want it registered. But different forms of trust.
Sorry, the line is not great. If you wanna, can repeat the question so I can understand the point clearly.
Never mind. I will just continue. Yeah, Mr. Russell, you want to continue on question 9, yes. Or have you finished on question 9?
If I could draw the court's attention to paragraph F of the additional words that are suggested. And the point there, I mean, whether they need to be included in the answer or not, we'd be perfectly happy for them to be included. But paragraph F refers the court to Article 13.2c of each of the trust law and the foundations law. They're identical. If I can take the court to the trust law provision, which is, Your Honours will find it on page 13.2c of the bundle. Sorry, it's on page. Now I've managed to get rid of. Let me get back to the bundle. It's on page 705 of the bundle.
Ayman, can you get it as to 705? Yes, thank you.
Your Honours will see that you have Article 13.2c makes it very clear that nothing in the trust law will validate any testamentary trust or disposition which is invalid according to the laws of the testator's last domicile, or in 2b, not validate any trust or disposition of immovable property situated in a jurisdiction other than the DIFC in which such trust or disposition is invalid according to the laws of such disposition.
This was what I was referring to you at the beginning. 2b is there. Okay, go on. Okay.
Yeah. So the law, the DIFC, both the trust law and the foundations law are very clear that if there is a contravention of Article 361 of the personal status law, which would be something decided not by this court but by the onshore courts, there is no conflict with the trust law, because the trust law doesn't seek to treat that transaction as having occurred. Quite the reverse. It says it isn't valid. And that is picked up in paragraph F of the proposed answer. So it is, as Mr. Hamade said, that nothing in the trust law or the foundations law of its basic principle contravenes Article 361, and if as a matter of basic principle it did, you would not. We've included as schedules 3, 4 and 5 of our argument the comparison between the DIFC laws, the various emirate laws and the national law. We haven't included a comparison involving the draft federal trust law because it only became available to us a few days ago, but could do so if the court wished us to. But it's very plain we would submit, given the existence of laws in the Emirates, particularly the Emirate of Sharjah, where there's a particular emphasis on the application of Sharia. The fact that those laws exist is consistent with the view we're advancing, and which Mr. Hamade has advanced, that there isn't any necessary conflict between the concept of trust and foundation on the one hand and Sharia obligations on the other. But quite independently of that, we would say that the question's resolved by Article 13.2c of each of the trust law and the foundations law. There simply cannot be a conflict, because if if the local, if the law of the outside the DIFC has operated to invalidate the disposition, then the property doesn't come into the trust in the first place. Those are our submissions on question 9, unless the court has anything further for us.
Yeah.
Question 10 relates to Article 7 of the Judicial Authority Law. The court has the Judicial Authority Law in...
Can Mr. Russell, it's 3 o'clock now. Can we take a short break? Say we take a break of say 30 minutes. Is that all right with you, Judge Ali and Judge Robert French?
Yes, sir.
Can we take a half an hour break now, or is it too long? You want a 20-minute break or half an hour break? What shall we do?
I think we're very grateful to the court for being available at what must be quite inconvenient times, and
no.
the last thing we would do is suggest that Your Honours don't have an appropriate break.
You are the one who's talking, not us. We're just listening.
I think Chief Justice, Mr. Russell doing great, I mean, by finishing almost in a very short time. I mean, there is only three questions to be answered by him. If you give him time, he might finish in 15 or 20 minutes at the end of this.
He doesn't start over again.
But
he's finished
I'm
with
okay.
9. He's going to 10 now. I was thinking that we should stop now and then he can start with 10 later, because they will take another maybe 20 questions.
They are, with respect, very, very simple. I would expect to be able to answer them very quickly.
Okay, then let's proceed. And we won't take a break. We won't take a break. Are you ready to continue, Mr.
Yes,
Russell? Or you want a break?
No, I'm perfectly happy to continue.
Okay, please go on to question 10.
Mr. Russell, you started off dealing with these questions in the framework of are they interpretive or not. But my sense is that we have also touched on the key points of the merits as we've gone along. We wouldn't want to, imagine, cut you off on the merits, but can I assume that, or can we assume that you have been dealing adequately for your purposes with the merits?
Yes, indeed, perhaps with the exception of question 2, where you have the contrary submissions of Al-Tamimi, where you have to resolve a difference of approach, and that I'd envisage dealing with that separately. But other than that, indeed, the Judicial Authority Law is document 24 in the case bundle. Sorry, in the court bundle. It commences at page.
Where are we now, Mr. Russell? Where are we? Are we going back to question 2, or are you on question 10?
I was just going to go ahead and do question 13 on essentially jurisdiction.
Yes.
And then after the break deal specifically with question 2, and it may be better from the court's perspective for you to hear the argument from our learned friends first, but I'm in the court's hands.
Okay, let's do what you suggest. But I thought as we went along just now, you were also dealing with the substantive issues on those questions, not just the threshold issue, whether it's a question or not. I thought you have substantially dealt with them, you know?
To a large extent, yes. I would be inclined, once I finish this, I'd say a few words about question 2, and then I'm simply subject to any questions the court may wish to ask me.
Fantastic. So let's go to 10, and then later on you can revisit some of the questions where you don't feel you have said what you want to say, then we will allow you to speak more. Let's go to 10 now.
Yeah, it's only question 2 about which I wish to say anything, and that will be less than 5 minutes.
Yes.
On question on question 10, the article that has to be interpreted is Article 7 of the Judicial Authority Law, and our submission is simply that it is a totally general provision. Sorry, I'm at page 763 and 764 of the bundle. It makes no distinction whatever in relation to orders made under particular laws. And that being so, we would say that the answer, first of all, that it's clear that this is a question that goes to the jurisdiction of the court, and second, that the answer is clear. That's a view that's common. That's a view that's common to us all. Question 11 is a question where the parties have asked the court to answer the question with slightly added form, and you have, as one of the documents sent yesterday, a revised submissions in relation to question 11, which replace the revised questions and proposed answer appear at pages 279A and B of the submissions, and they replace the submissions on question 11 in our initial submissions. They don't raise any different questions, and indeed our original submissions raised a question of the nature of an interest of the trustee in trust property. So there's no new issue raised by this in terms of something.
What's the law, the trust law on this? Can a trustee, a shareholder, become a trustee? Basically, that's what the question is.
Well, it's really, is there any reason why the settlor can't be a shareholder or director of a trustee company that's prohibited, or they are prohibited from doing so? We would have said the answer is clearly no, and that the shareholder, by definition, doesn't have an interest in the trust property. This, unfortunately, is one of those questions, again, where Justice French would say quite reasonably that we're asking a question to which the answer is obvious. But again, that's an issue that's been raised time and time again with the profession. It was raised with the Wealth Management Review. It's raised in Mr. Hamade's book. But we would say it's plainly within jurisdiction, and we would say there's no controversy about the answer.
Because a shareholder, the director on the board of a company is basically a trustee. He holds a fiduciary position as against the shareholders of the company.
As technically, we respectfully suggest that be rephrased, that his fiduciary duty is to the company itself.
Yes, that's fair. That's a statement.
But the point, in any event, is that there is no reason why a company can't be a trustee of a trust. A private company can't be trustee of a trust. Indeed, there are references in the trust law to corporate trustees that make that clear. And once again, very clearly, a trustee that's a company, let alone a shareholder in such a company, doesn't have an interest in trust property. We wouldn't have thought, as a matter of company law, there's any issue about the correctness of those propositions.
Assuming the shareholder holds, say, 90%.
Yes.
In the company, 90%, and he's a director, he's being a trustee for himself, isn't it?
No, because the question would be, who is the beneficiary of the trust?
He is, because he's, or you're in that context, I see. The non-shareholder, the person outside is here. Okay. Okay.
Paragraph 12 relates, question 12 relates to the remedial powers of the court in relation to this again comes back to the concern that many settlors or founders have, that one way or another their lawyers may not get things right, whilst they've intended to be fully Sharia compliant in their dispositions. They may in some way have made a mistake, or the lawyers may have written their instructions down incorrectly. And the question that's posed by question 12 is whether the jurisdiction that's conferred on the court is sufficient to empower the court to correct the mistake. And this, we've dealt with this at some length in our submissions, but this essentially is the application of provisions that were enacted in the trust law to give statutory effect to an English decision called Re Hastings Bass, which was subsequently reversed in the Supreme Court. If I can take your honours to the provisions, and once again, the provisions are identical in the Foundations Law, but your honour will find them 24C and 25(2)A are at page 709 of the bundle. And your honours will see that the court under Article 24(2) C, under 24(2), can, on the application of a person specified in Article 28(1), and that includes a set law, can declare a transfer or other disposition to a property to a trust by a set law is voidable and has such effect as the court may determine, or was of no effect. And then 24(3) sets out the circumstances in which that applies, which is where the set law has made a mistake. So that's the power, if they've made a mistake, to get the trust, to get the disposition set aside or have effect on terms which are Sharia compliant, because the court clearly has the power to determine that the disposition has such effect as the court may determine. Under paragraph 25(2)C, you have, 25(2)A, you have exactly the same provision if the trustee makes a decision in relation to, if there's been a misapplication of property to the trust. And then paragraph 40, Article 48A is the court's power of variation, which is expressed in very wide terms. It goes beyond the normal concept of rectification that would be available in any event. And your honours will see, this is on page 716 of the bundle, your honours will see that the court may vary the terms of a trust, even if unambiguous, to confirm the terms to the set law's intention, if it is provided by clear and convincing evidence that both the set law's intent and the terms of the trust were affected by a mistake of law, whether in expression or in inducement. So we would say, and your honours will see that there's a slight amendment to the applicant's original suggested answer that comes from the Al-Tamimi submissions. But the short point is that under those provisions, there's ample scope for the court under those provisions either to determine that the disposition has effect on terms which are Sharia compliant, or if necessary to vary the terms of the trust to have that effect. And as we pointed out in our submissions, Articles 24.2c and 25.2a of the trust law have their counterpart in the foundations law. So in our respectful submission, the answer is almost self-evident, and the power of the court and this clearly relates to an interpretation of the legislation because it relates to the powers of the court under the law. Question 13 again relates to
Mr. Russell. Before I forget, are these meant to apply only to Muslims, or can a non-Muslim in the DIFC also?
Anyone can rely on these provisions. The point that's been identified in the material, both in terms of submissions to the Wealth Management Review, in Mr. Hamade's book, and Your Honours will see in due course the submissions from STEP and Al-Tamimi, that this is an issue of recurrent concern amongst the community. So whilst the question has been asked in the context of a Muslim settlor who is concerned about Sharia compliance, it applies to any mistake falling within the terms of the legislation. Articles 24 and 25, as I mentioned, restore to the court the jurisdiction in England that was provided under the Hastings-Bass case, which of course had absolutely nothing to do with Sharia and a great deal to do with income tax provisions in the United Kingdom.
Yeah, okay. Continue. Yes, go on.
Question 13, again, this takes the court to the issue of public policy. We've put in detailed submissions on the nature of public policy in the DIFC. They were our third bundle of submissions because after we initially put in our submissions, there was a very interesting discussion on the nature of public policy in the DIFC in a case by decided by Justice Al-Sawalahi, in which he dealt with how public policy in the DIFC interacted with public policy in the wider UAE. And it seemed to us, because there are a number of provisions in both the trust law and the foundations law which refer to public policy, that we should address the nature of public policy. I'm happy to take the court to that later, but if the court wishes. But the short answer is that article public policy, there may be an argument, and as I've already indicated in relation to Article 13.2c, there may be issues for Muslims having regard to their Sharia obligations in the establishment of trusts. The real point that we're seeking to identify in Article 9.2c, or the interpretation of public policy, is that these are not matters that have no application to non-Muslims. And for that, whilst we would say it's clear from the terms of public policy in the DIFC, in our submissions, if public policy in the DIFC includes a reference to the laws of the wider United Arab Emirates, we say we get to the same result. And in particular, there's a provision in the UAE law of personal status which allows a person who is not a citizen of the United Arab Emirates to adopt his own national law in relation to dispositions of this nature. So we simply say that you can't say that dispositions are contrary to public policy, because for some people within the United Arab Emirates they may be problematic. Again, we say clearly a matter of statutory interpretation, and one whose answer is self-evident. Do your honours wish me to deal very briefly with question 2 now and then have the lunch break?
Yeah, you can.
Okay.
Any questions on any questions from Judge Ali or Judge French on the 13th? No? If no, then yeah, we can.
Sorry, can I just make the observation? The question is not just one of interpretation of Article 9(2)(c). It's about the content of public policy, which is a fairly variable thing around the world. I know in the context, for example, of public policy grounds for non-enforcement of arbitral awards, which I think you mentioned somewhere in your materials. There was a survey done by the IBA a few years ago, and it's as many opinions as there are jurisdictions. I appreciate it's a narrow question you're asking, but I always feel nervous about getting into statements about what is and is not public policy anywhere. It's not just a matter of statutory interpretation, it seems to me.
Your Honour has very kindly not referred me to Justice Burrow's description of public policy as an unruly horse. In many ways, the best analysis, if I might respectfully submit it to this issue, is a decision in which Justice Prakash of this court took a part in UKM and the Attorney General for Singapore, which we've included in our list of authorities. And it's also the subject of an article by the Chief Justice of Singapore in a paper given to the Malaysian Judicial in the
conference.
Judicial, yes, Malaysian Judicial Conference, both of which we've included UKM in our cases. It is case number. It's case number 70, and Chief Justice Menon's article is in it's document 89 in the bundle, and they are. That is, Chief Justice Menon, in fact, entitles his article "Taming the Unruly Horse." So the court set out to address these issues and did make the point, to pick up Your Honour Justice French's comment that this necessarily is a question that has to be answered within the jurisdiction, and in federal jurisdictions it creates particular problems because you have various authorities that are capable of creating laws which in turn might affect public policy. In a narrow area, we would very much understand that the court would be reluctant to say what the content of public policy is. And certainly if it were a very narrow question that had a fine answer, we wouldn't trouble the court. In the present case, we say it's very, very easy to answer, if only because the laws of the United Arab Emirates, well, for two reasons. First of all, the laws of the DIFC are, in a sense, not directed to particular religious questions. And so far as the laws of the United Arab Emirates are concerned, they expressly say that persons who are not UAE nationals have the right to adopt their national laws in relation to their own transactions. And we've set out the basis for that in our public policy submissions. If I can...
To answer any questions, we think it's in the circumstances of the law and what because they're not relevant or not safe to answer, can we refuse to answer your question?
I was actually giving some thought to that in the sense that the jurisdiction of the court arises because Your Honour has made a decision, and one view of the matter might be that that Your Honour the Chief Justice having made that decision, it follows the question should be answered. We think the correct answer, and we submitted it to Your Honour, and it's in our submissions, is the decision in Attorney General of Ontario and Attorney General for Canada.
Yes.
We've set that out in our submissions, and we set it out too in the letter to Your Honour.
Yes.
It is, it's a little confusing in the sense that it's reported under different names in the Dominion Law reports on the one hand and the United Kingdom reports on the other. But it is document, and there are two cases called Attorney General Canada and Attorney General Ontario. Yes, it is. It's case 47. That was interesting because obviously members of the Privy Council had the traditional common law view that they shouldn't have to answer hypothetical questions, but they were sitting on appeal from the Supreme Court of Canada, which did have that constitutional duty. And they discussed it and concluded that much as it may be the sort of exercise in which they wouldn't normally have engaged, it was, in a sense, as a review court, part of their duty to assist if they could, but they made it clear that if they thought either the question shouldn't be answered or that it should be answered in a qualified way, that was the appropriate course for them to adopt. And our submission, Your Honour, the Chief Justice will recall, that was our submission to you at the time.
Yes.
And it remains our submission.
Okay, thank you.
What we would invite the court to do, however, in areas where the court feels either the question is too broad or that any answer needs to be qualified, that the purpose, whilst we're not trying to impose on the court in terms of additional work, because it obviously takes more time to answer a question in detail than to not answer it, for the purposes of the jurisdiction, the jurisdiction is just as likely to be assisted by the court's reasoning as to why a question isn't answered as it is by an answer to a question, because what arises from it all is a body of precedent which enables persons considering use of the jurisdiction to appreciate that the courts will approach the issues that arise in relation to trusts and foundations in a manner that is appropriate to a conventional common law jurisdiction. So we would, if in a sense, I think in retrospect I have covered virtually everything that I could say on question 2, because Justice French will recall that he had a number of quite searching questions dealing with the matter. He took me to the provision of the Foundations Law which defines what the property of a foundation is. We looked at the provision of the Foundations Law which talks about its powers. He raised the question of constructive trusts. We would add that necessarily there's a resulting trust. If a settlor were to give, or an intending settlor were to give property to a foundation on its undertaking to hold on trust, and the proper analysis was that the foundation had no power to act as trustee, no court would permit the foundation to keep the asset. A court would say that it was held on resulting trust for the settlor, just as always happened in the context of trusts that failed for breach of the rule against perpetuities, which fortunately we don't have. So there can be no question that a foundation can act as trustee. And indeed, our learned friends Al-Tamimi don't submit that. What they submit is simply that it is disentitled from acting for individuals as trustees because of the wording of Article 10.3. In our respectful submission, as Your Honour Justice French said, our submission is that those provisions deal with the nature of a foundation, and if one had to go to a specific provision, of the law. It's the provision that says that a foundation may act in the same way as any other individual. Those are our submissions, subject to anything that the court may have for us after the luncheon adjournment. Or dinner adjournment, I'm afraid, for you.
No, tea. It's tea for us. It's tea for us. You are, what time are you now? You are 11:30, isn't it?
Yes.
11:30. We are 3:30 p.m. I need to take a break only because I need to go and do my prayers. So, what shall we do, Judge? Shall we take a break for, say, 30 minutes, or have you finished with Mr. Russell? I would like to suggest, Judge Umar and Judge French, that we take a break, we discuss something amongst ourselves, and then if we need to revert to Mr. Russell, we'll call him back. You'll be in the office, Mr. Russell? We can always request you to join. You can always request you to join the sort of call back the court hearing, you know. But in the meantime, we let you off for now. I would like to discuss something with Judge Omar and Judge French on our own without others participating.
Yes.
And then if we need to come back to you with more questions, then we'll invite you. But before
Thank you. Chief Justice, might I interrupt? It's Patrick Dillon Malone from
before that, is there anybody else who wants to say anything?
Well, there certainly are some brief submissions.
Who's this?
Patrick Dillon Malone from Al Tamimi and Company.
Okay. Sorry, Patrick.
Thank you. Chief Justice, I'd be very grateful for an opportunity to address the court in sequence, as briefly and succinctly as I can,
I see.
A number of the issues and points that have arisen. I think I could probably do that in 30 minutes. But I think
30 minutes too long for me. I want to take a break now.
Oh no, after the break, of course.
Take a break now.
So
let's take a break first. Say 20 minutes break, and then we come back again with everybody and then we decide what happens after that.
The reason I suggested that was because it may be useful to hear me in advance of your deliberations. But if not, we can do it the other way around. Yeah.
That's fair. Sorry, I forgot about you, and maybe anybody else who want to also address us. I should have invited you to, but I have to take a break now if possible. Can we take, say, 20 minutes, half an hour? What do you think? Normally, what do you think? Half an hour? Huh?
Half an hour.
Half an hour.
Half an hour. Okay. 30 minutes break, and then we'll invite our IT teams. We invite you back in 30 minutes. Let's make for 5 minutes past 12. Is it? Yeah, for 5 minutes past 12.
Thank you.
Okay, thank you very much indeed. We'll take the adjournment now. Thank you.
Thank you. Bye.
Sir, we'll keep it connected. Everybody will be connected at the same network.
Yes, Sajaz, that's probably a good idea, although I think people have already come off the call, but I guess we can... some people have to rejoin, I guess.
Yes, is everybody ready?
Yes, right.
Okay, Patrick.
Thank you very much, Chief Justice, and Al Tamimi and company are very grateful for the opportunity to participate in this hearing and to have made our written submissions. It may be appropriate for the court to have in front of you the written submission that's been made by Al Tamimi, because I'll be making reference to it, and it may assist in time.
You have given only one submission, isn't it? Only one.
That's correct.
Okay.
That's correct. Just in terms of our role, we of course are supportive of this application, and we see our role as a practitioner in the region in the area of wealth management advice and advising on structures, as that these references and these questions are relevant, and that the answers to the questions that the court is consistent with its jurisdiction and the exercise of its discretion, we believe will greatly assist in our task as advisors and representatives. We have, of course, a duty to the court in this test case participating role. And my own experience of that comes from Ireland, where we have a jurisdiction in respect of the constitutionality of statutes, either prior to their enactment, in which case the questions asked are entirely abstract and the answer given is written in stone to the effect that that legislation, if approved, is constitutionally challenge proofed thereafter. And both in that jurisdiction, yes?
Are you aware of, I've looked at a number of jurisdictions, a number of the American states have advisory jurisdictions also, but yes, they all seem to be related to the constitutionality of proposed legislation. Are you aware of any advisory jurisdiction in relation to the interpretation of statutes?
I think that the examples that have been given by the DIFCA submission are the ones of which I'm aware, but I'm not aware of it as certainly not in the abstract, in the sense that we have the jurisdiction that was considered in the Canadian cases, and in the UK you have the Attorney General references. But they are very much specific and arising on the facts of specific cases, which give rise to issues of general importance. And of course, those have the advantage of being put in the context of a set of facts and a dispute.
Even those cases on constitutionality is based on specific facts. In cases, but they become advisory rather than it's not enforceable. It's only advisory.
Yeah. Yes, yes. The answer in Ireland is that the answer is both yes. In the case of any particular dispute, any party to any litigation can challenge the constitutionality of a provision, and can do so in the High Court or the Supreme Court or the Court of Appeal. The prior power to refer a bill to the Supreme Court is a power that is set out in the Constitution and is reserved to the Attorney General of the government of the day. But in doing that, quite interestingly, the Attorney General will appoint a team from the bar to argue for the constitutionality, and a team against the constitutionality. And there may also be specific interest groups, or indeed the Human Rights Commission or other amicus curiae that may participate in that exercise.
That is my problem here. We are not hearing something in opposition.
Yes.
You can come in as amicus curiae. I mean, I can treat you as amicus curiae. But you started off by saying you have an interest to see that this law is also, I mean, what?
Yes.
the IFC is seeking for is also, you know,
yes, well,
for your benefit. So you are sort of biased in their favor.
I don't. I can see where you might see that. I'm not strictly neutral, but in the sense that I did also qualify that by saying that consistent with with it being within your statutory power under Article 5, and also in the exercise of your discretion, and I'll come to that in a minute. But I think I wanted to say very specifically to perhaps allay those concerns that we see our role as being one primarily to assist the court on these questions.
Yes. Okay, you're amicus curiae. We accept you as amicus curiae. Friend of the court. Okay, go on.
Thank you very much. So from that, I'd like to say also that we do bring, I respectfully suggest, some perspectives that are reflected in the submission that are practical. For example, in relation to what we've said about how we advise our clients in respect of WACC vehicles, in respect of the use of discretionary versus fixed trusts, in the context of wariness of or being ensuring that instruments that we adopt and recommend are operable in a Sharia context. And also having regard to Article 361 of the UAE law. And in that regard, I'll come to that. But as you've seen in our submission, we do believe that that has to be approached on a case-by-case basis. And that in practice, we've also indicated that what tends to happen if a conflict arises is that there would be a divesting solution, so that any person inheriting in an interest under a foreign law, that interest of the units of the trust could not be held, for example, that those units would then be divested, and the trust would continue, and with the adjustments that are appropriate to that. And equally, the foreign law would be protected. And the trust law contains the firewall provisions in Articles 14, etc., that preserve that operation. And we think that that is an important practical perspective to bring at the outset to some of these questions. Having said that, we do agree very much with the submissions that have been made, that in practical terms, as a matter of practice, there is a great deal of hesitation around some of these questions. And we agree with Mr. Russell and the submissions that have been made by DIFCA, that whilst the answers in some cases may appear self-evident and hardly a matter that requires interpretive clarification, nonetheless, the assistance that could be given by this court as the authoritative court in respect of the interpretation of the trust law and the foundations law would potentially greatly assist, and to that extent we are supportive. Just turning then to the question of the threshold for your jurisdiction. Obviously, it must be a question of DIFC law and not, for example, how a foreign jurisdiction or might view the operation of DIFC law. And I think that there is a certain difficulty in some of the questions with that, and I think our best efforts have been made, and on the court, I see from its very helpful interventions so far, I think is concerned to ensure that any answer that is given, that can be given, would be one that operates and can be adjusted to ensure that it is a matter of DIFC law. And we have said, for example, that the question 8, in our view, really relates to, as it's presently framed, relates to foreign law and ought not to be answered on that ground. Also, it must be a question of statutory interpretation. And I think that's quite clear, that's very clear from the words of any article in Article 5B1 of the Judicial Authority Law.
But Mr. Miller, when you mean the DIFC law, you mean that all laws applicable within the DIFC and can apply by this court, including federal laws that's never been exempted and is still applicable to that extent?
I don't believe so. No, I don't believe so. I think this is an exceptional jurisdiction that is granted to this court as the authoritative court for the interpretation of DIFC law, meaning laws enacted within the DIFC. I would be surprised if that same jurisdiction could be exercised over a federal law. And as Justice French has very much pointed out in saying that there are really two questions. One is the question within your jurisdiction? And then the second one is there, as a matter of discretion, ought you give an answer to the questions asked? And I just refer to two particular references in the materials. I don't propose to open them. The first is the dictum, which is very well known and was approved in the Canadian case of Viscount Haldane at page 1573 of the bundle, where he very succinctly and authoritatively summarizes the hesitations that a common law court or that any court has in answering questions in the abstract. And in relation to that's a reflection also of the wider discretion that the court would have in respect of all declaratory exercises of its declaratory jurisdiction. And there's an article in the materials in respect of the general approach to declaratory jurisdiction. I'll just find the reference. I'll come back to that. I seem to have temporarily lost my reference to that. But nonetheless, it is clear that the court, for the reasons we've urged in our written submission, ought, where its answers under the express terms of the statute will have the same authority as legislation, naturally must exercise caution. So turning to question 1, I want to just clear up, I think some of our analysis in our written submission is a little bit too compressed and cryptic, and I've just quickly clear that up for the benefit of the court, if I may. We rely, and we think that almost the complete answer to question 1 is very helpfully reflected in the judgment of Lord Mance in the Acres case. And if I could refer you, I'll give you the references. It's at paragraphs 20 and 21 of Lord Mance's judgment in Acres, and from paragraphs 24 concluding at 34 of the judgment. And that's in the bundle. They're at pages 1598 to 99.
لقد تم وضع مكالمتكم في الانتظار من قبل الطرف الآخر.
What's that? Hello? Can you hear me?
Yeah. There was an Arabic. Somebody was speaking in Arabic.
Yes.
I'm multilingual, but not that good.
Ajaz?
Sorry, someone said the call was in waiting, but it's no longer, I guess. I can hear everyone.
It must have been an echo.
Okay, continue.
And the other page reference is paragraph 16, sorry, page 1604 of the bundle. I'm getting an echo now.
Yeah, we are getting echo.
Hello? That's better, I think. Oh, no, it's coming, still coming.
It's still echo.
I think so from Mr. Maran's side. You're the only one having that echo.
Okay. How's that now? Is that better?
Yeah. It's okay.
Thank you. Thank you very much. So we rely on that. We think that provides a complete answer. Please don't, when you look at paragraph 18 of my written submission, of our written submission, the Rangers case is not something we rely on. In fact, that goes the other way. And the Lambton case is really an example of where Italian inheritance law applied, and therefore it's not on point either. So please ignore the references to Rangers and Lady Lambton, and we very much rely on Akers. And again, on the judgments in Investec of Lord Mance, again, there were various judgments and there was a majority and a minority in that case. But the references at paragraphs 200 to 201 and 227 to 231 of the Investec judgment of Lord Mance, we think are very useful in answering the question number one positively. In terms of how mandatory foreign law interacts with property coming within.
We are getting an echo again, Ajas.
Can you turn off your phone? I'll maybe take my phone away.
Yeah, maybe that's the reason. Okay.
Can you turn off your phone? Is that better?
Yeah.
Yes, that's fine.
Thank you. In terms of how mandatory law in the foreign jurisdiction then interacts with, in respect of property located in that jurisdiction, whether real property or shares, the case law, in summary, seems to indicate, and we believe that's correct, that while the legal interest in respect of that property under a mandatory provision of foreign law may be impacted by that mandatory law, nonetheless, in terms of a trust and the operation of a DIFC trust, it's the equitable rights and personal obligations will continue, and that seems to be the effect of the Akers line of cases. And whereas, of course, we agree with Mr. Justice Russell, with Mr. Russell, that the Akers judgment provided welcome elucidation of this. Nonetheless, the judgment, Lord Mance's judgment, does contain references to how those principles were applied in previous cases, and we recommend it to this court. If I then may move to question 2, I think the key to this difference of opinion, if I may submit respectfully, is that the reference in Article 28 of the Trust Law to foundation of a property of a foundation, I think has to be interpreted as property that is the sole property of the foundation. And that I think reconciling Article 28 with the difficult and clear provision of Article 10, excuse me, I'll just find the reference.
Paragraph 28. Paragraph 28.
Article 28 of the trust law, of the foundation law, excuse me, provides for the definition of property of a foundation, and that's a wide definition. And then when you turn to Article 10.3, which contains the prohibition on the foundation holding property for the benefit of anybody else, I think reconciling those two, it doesn't lead to the answer that Article 28 prevails over Article 10
Why do you say 10.3 is a prohibition?
Because by its clear language, it says that the property of the foundation shall not be held for the benefit of any other person.
Well, it doesn't say it should not be, it says is not.
Is not, yes.
May just be declaratory in relation to something called the property of the foundation, Martin.
Yes, but I think on our analysis, the property of the foundation is the property held by the foundation for itself, and that as soon as it is, if property were conferred on the foundation that was in trust with other beneficiaries, then this does give rise to a problem. And I accept that may not have been the legislative intention, it may be clumsy wording, but on our interpretation, it is not capable of being ignored or reconciled in that way, because a trust, by definition, property has to be held for the benefit of yourself and somebody else.
There's a settlor, a trustee, and beneficiary. Settlor, trustee,
yes.
Beneficiary.
Yes.
That's a trust.
Yes.
If I still remember my trust law.
Yes. Entirely correctly. I think that this I know from my corporate colleagues and wealth management colleagues that this does give rise to problems, and it does seem to be unfortunate wording. It maybe requires a legislative solution. I don't think.
What does the Arabic? Have you got the Arabic? Judge Ali, do you have it in Arabic?
So no, it's not in Arabic.
Okay, thank you. It's all right. Please go on, Patrick.
Yes, I think that the only other point I wanted to make was that I think 2 points. First of all, I think when Justice French said that that there was a difference between a trust and a foundation in the way that the property interests are different, and I think that it's consistent with the legislative scheme that this prohibition exists, and I accept that, and we have accepted in our written submission, that if a constructive trust were to arise by way of equity, then yes, a court will give effect to that. But I don't think that is what this legislative prohibition is designed to capture. It seems to be one that it doesn't leave room for the foundation to hold property on trust for any other person.
Okay, yes, go on.
In terms of question 3, again, the answer is suggested very strongly by the terms of Article 10.1 of the Trust Law. And we agree, of course, that the waterfall provisions of Article 8.2 of the Law on the Application of Civil and Commercial Laws in the DIFC doesn't give rise to a binding effect of English law in this context. And we fully agree with what has been said so far by the court and indeed by Mr. Russell, that the manner in which common law and the rules of equity develop and are elucidated and identified by this court is the same as it is in Ireland or in Australia or in Malaysia. And it's a very rich tradition that we benefit from around the world. I think we've identified that, I think there's a reference in one of the cases to the Commonwealth, which appears to be a slip of the tongue, and coming from a Republican tradition myself, and nonetheless a common law country, I think it is not the Commonwealth but the common law and principles of equity that apply. And also, I've noted very carefully and agree with Justice French's suggested reformulation of the answer to this question of 3.1, where he said we should avoid the word includes and maybe use the words drawn upon. And I respectfully accept and adopt those suggestions as being very sensible for the reasons that he's identified. I think that covers also my answer to 3.2. It is, again, probably obvious to all of us, and it is the practice of this court already, that this court may look to the jurisdictions and authoritative judgments of other common law jurisdictions, from Singapore to Hong Kong to Ireland, even India, and provide its own answer based on the wealth of comparative authority that's available to it. Turning to question 4, again, this is a question which, from the terms of Article 40.12 of the Trust Law and Article 19.11 of the Foundation Law, suggest themselves. When you have an irrevocable instrument, it cannot, under the terms of those statutory provisions, be altered, including by a court. In respect of the question that Justice French identified, where, for example, a constructive trust might arise, or where the rights and obligations of third parties might be impacted by the inflexibility of the trust instrument, and he has a hesitation about answering that question in the abstract. We agree respectfully with what David Russell has said in this respect, that interest and that obligation will arise outside the instrument of the irrevocable trust. So you'll still have the express written trust, which is irrevocable and will remain as such, but you may then have that irrevocable trust being impacted dehors, in the French word dehors.
Patrick, can you pause there for a while? Can I see 40.12 again? I just want to have a look at it again.
Yes.
40.12 and 19.11.
40.12 of the Trust Law, yes.
19.11.
Perhaps Ayman might be able to assist.
Can you assist me? Can you assist me 40.12 and 19.11? I just want to see the wording again.
Thank you, Justice. The Trust Law starts on it's 40.12, yeah.
Was it quoted in the Mr. Russell's submission? Can't remember.
Yes, it is.
It is, yes.
It is.
I think I can find the page number, Chief Justice. It's, yes, I think 716.
I'm on 716.
717, excuse me.
717.
And I think, Chief Justice, if I'm correct, the equivalent provision in Article 1911 of the Foundation Law is in near identical terms.
No, I just want to, as you are submitting, just crossed my mind that.
Thank you.
Well, if it's too much problem, then let me look at it again later.
Thank
Don't
you.
worry about it.
I refer finally in relation to this question to paragraph 45 of our submission, written submission, where it's a practical gloss again on this, and that if, in the example that's been given of a constructive trust arising, there were a difficulty, in practical terms, that the units will be cashed out and redeemed from the trust to give effect to the competing legal obligation, to the not competing but overriding legal obligation. And in that way, everybody goes on their merry way, respecting the entire legal obligations arising. So if I may, with the permission of the court, move to question 5. I think the key point that Al-Tamimi wished to make in respect of this question is that as a matter of DIFC law, DIFC law is really strictly neutral as regards Sharia law, and the primacy of the trust is the key and critical consideration. And therefore, whilst of course, and for very good reasons and very practical reasons that have been emphasized, an advisory trustee within the meaning of Article 57 can and ought to be or can be appointed in respect of a DIFC trust as an expert on Sharia. And we've noted what you, Chief Justice, have said about the Malaysian advisory boards, and indeed what Mr. Russell has said about the committees on Sharia that will benefit the operation of instruments more generally. But the key point we wish to make is to remember and bear in mind that DIFC law is strictly neutral on these matters, and that the trustee has an overarching duty to give effect to the terms of the trust, to preserve the property of the trust, and that there would be a constraint not only on the trustee but also on the advisory trustee in advising or in acting contrary to their obligations, consistent with the intentions of the settlor. In relation to question 6, we do have a difference of opinion with the authority on this. Really doing our best. I just does not seem in our respectful submission to be a question that can be answered. The 6B and C in respect of the exercise of a statutory licensing process effectively in the abstract in advance by reference to instruments that are going to be converted on a case-by-case basis from foreign law mechanisms or foreign law instruments. And it just seems, as the Chief Justice suggested, the answer, I suppose, is yes, you register your Waqf as a foundation, and that solves the question. But whether and when and how you do that is set out in the legislative scheme. The legislative scheme creates a process whereby that is achieved, and the starting point for that process is foreign law or the foreign instrument. In respect of 6A, it's true, we've said we agree, but I think it seems to be common case of all the submitters that Waqfs they do indeed have legal personality. I'm not sure if that's the case in all cases. As I say, our corporate team and our firm, Al-Tamimi as a whole, tends not to recommend the adoption of Waqf structures, as we find them inconvenient because they do require quite a degree of interaction with administrative authorities and constraints, and also the trust is available as a better instrument. But So I can't say for definite whether there is, and I've no instructions on that, whether there are WACs that have no legal personality, but my understanding from the submissions is that it may be universal, that they always have legal personality. And if that's the case, then question 6A may not be a question that should be answered in the abstract, because by suggesting, for this court to suggest an answer, might also suggest that it has a practical application. And I say that with hesitation, and I simply on the basis of what I understand to be the position, and without knowing in fact what the universal position is.
See, Mr. Miran, as in this question particularly, and then for other questions like other of the 13s, do you think would it be very much helpful that this court have the assistance of an expert in the Sharia and Waqf to deal with some of the doctrine and even some of the Islamic Sharia principle that this court, acquired to deal with?
Yes, I know that the authority has put some certain material before you, and perhaps Mr. Russell can address that in relation to interpretation from an Islamic scholar. I think we have approached this more from the point of view that the interpretation of the trust law and of the foundations law, that, as I've been impressing, DIFC law does not, for the purposes of the general interpretation of these statutory provisions, require to decide any issue of Sharia law, nor could it. But to the extent that it's relevant to your consideration of how DIFC law may be impacted by wider regional legal systems, and in particular by the UAE, of course this court should have the benefit of whatever expert assistance it requires. And I suppose potentially to the extent that following your deliberations you wish to have further input on that, I don't see any reason why under this jurisdiction you could not adjourn and receive that input, either on your own direction or through the good offices of the authority.
Yes, thank you. Go on.
Thank you. In relation to question 7, I should say, first of all, that I think in the submission, just coming back to question 6, I think there was a submission in the response submissions of the authority to our submissions on question 6 that a proviso to the same effect as the one that we suggested for question 7 might also solve the hesitation for question 6. I'm not sure if that is the case, but it doesn't seem to me that the same, I think as I said, this licensing function is one which would have to be performed on a case-by-case basis. I'm not sure what advance assistance can be given by the court. In relation to question 7, we have just suggested a proviso to the effect that in any concrete case, the statutory criteria under Articles 60 and 61 of the Foundations Law would be met and so decided upon in an application made under Article 59. Now, I suppose the court might say to me, well, isn't that just exactly what you said we can't do, because you're just having a renvoi to what would be considered on a case-by-case basis in the future. To that extent, that is true, but at least in this case, we're talking purely about DIFC instruments and the application of DIFC law without reference to a foreign law. Because the starting point for question 7 is that the foreign law will already have approved the terms of already have approved the transfer from that jurisdiction to the DIFC of the Waqf. If I may then, Chief Justice, move to question 8. We have carefully noted the exchanges of this morning, and I think you'll have seen that we proposed probably a creative solution to avoid this court trespassing on the interpretation of foreign law in this question. And it was offered in that spirit. And I think it is difficult to see how question 8 can be reframed in a manner that is interpretive of DIFC law. But our offer is there, and it stands to the extent that it assists the court.
So it's more like a comment rather than a question. It's a comment from you.
I think the spirit, it's offered in the spirit of assisting the court. I do believe that this is definitely a question that has a practical implication, and it does reflect a real concern in practice. And so I don't want to suggest that it's absolutely not a question that, if reformulated by the court in any way that you believed was appropriate, could not be answered. But it does seem to very much have at its core the way in which other jurisdictions may view the DIFC trust and not how DIFC law treats that trust.
Yes, please continue. Your half an hour is 40 minutes, Patrick.
Yes.
You promised.
I'll be very quick now. I'll be very, very quick.
Okay.
Question 9, again, the whole question of Article 361, there's been a lively exchange this morning. Justice Ali and our colleagues from discussing the nature of the test as to whether it's fraud or anti-avoidance. I'd refer you to footnote 4 on page 18 of our submission. Sorry, I can't read my numbers. It's paragraph 74 of our submission contains the statement that it's our understanding that from the perspective of Sharia inheritance rules, each disposition requires to be examined on a case-by-case basis to establish whether, in essence, the transaction is or was meant to circumvent Sharia inheritance rules or not. And at the footnote, we've said we would like to make further submissions on the Arabic nature of that, Arabic language. But Justice Ali has done that, and I wouldn't venture to say anything further on that. But I do say that the language in paragraph 74 that we've used, in essence, the transaction is or was meant to circumvent Sharia inheritance rules or not, is the language that my colleagues who deal with this on a day-to-day basis carefully suggested, that that's their understanding of what would apply. It is something which does not, it's somewhere between the effect and the intention. Just because it creates an effect doesn't necessarily mean that it's but it is, as Justice Ali said, more of an anti-avoidance. So it does include a consideration of intention, of what was meant by it. As to the interpretive question, we urge the court to answer this question, and we appreciate fully that the answer that we've given is nuanced and calibrated with a series of propositions, but we do think that those propositions each stand as certain propositions, and we do believe, in common with the authority, that providing these answers will greatly assist in allaying some of the concerns as to how the Article 361 or equivalent prohibitions in other jurisdictions will interact with the IFC trust law. I think I've referred there to the question of fixed versus discretionary trusts. That's an aspect, a practical aspect of our answer to that as well. And I refer you to paragraph 73D of our submission, where we believe that a well-advised settler can provide for a fixed trust, in the sense that fixed interests in the trust will vest on death in a sufficiently certain way to ensure that Sharia law is respected, and that a wide discretionary trust is, in the, as we understand it, purely discretionary trust as common lawyers, would give rise to potential conflicts, and they would be then resolved.
When the trust transfer, or if I'm a settler and I say I want to give this property to so and so, when does it take effect? Is it immediately or on my death? Or when does it take effect?
I think, well, it depends on the jurisdiction, I suppose. But if it were in Ireland or England, I think the answer would be that the probate exercise that is carried out is an administrative administration of the trust. So in practical terms, you may not get your hands on the property until that process is cleared. But in terms of the legal vesting of the interest, it happens on death. And I think the question you ask is very interesting.
Yes.
Because in this particular context, I've had this discussion with our corporate colleagues, Richard Catling, partner in the Al Tamimi corporate department. And he said this is where this idea of divesting the units comes from in our submission, that in practical terms, it's my understanding that in onshore UAE or other Middle East jurisdictions or other jurisdictions applying Sharia law, that there is this window during which, for example, the units of a trust can be divested and distributed in a way that respects the inheritance provisions. Is that what you were?
That's what I was thinking, Judge Ali. The difference between a will, a Muslim cannot divest, what you call, cannot give away more than 1/3 of his asset or his but hiba, he can do it immediately. Do you is that correct, Judge Ali?
Yes, this is my understanding. This.
So during the lifetime, there's much greater freedom. Much greater freedom.
Yes.
That's why you should always be nice to your relatives.
I cannot divest on my death by will of more than 1/3.
Yes.
More than 1/3 to a person who is not eligible under the. But I can hibah, I can give now.
Yes.
But that hibah is revocable, right, Judge Ali?
Well, yeah, with certain condition, not in the old times, I guess. I mean, with I mean, I can't recall the exact law.
What I'm trying to say to that, what I'm trying to drive here is that would settler or they be allowed to overcome these restrictions by putting it on a trust, and then he being the trustee, and then as a trustee he said, I can do anything I like.
Yes.
Isn't that the purpose of 391? We were discussing just now about 391.
I think I would not venture to suggest what the purpose of Sharia, the Sharia. I think it has a much, as Justice Ali has said, I think it has a much wider societal and religious purpose. But the answer, I think, to your question in the statutory scheme and the law of trusts is that one does have reserved powers to settlors. And the settlor in this part of the world, the trust law actually contains the DIFC trust law contains quite interesting provisions on the reservation of powers to the settlor. If it were the intention,
those are the things that Judge Ali and I, being Muslims, have to be cautious about, And Judge Ali, we have to put some caveat or some reminders in the whatever judgment we give, Yes. I'm very cautious about that part of it.
Yes, indeed.
Never mind. Just go on, Patrick. Just go on with the submission.
Can I just maybe 2 minutes on that, because that's very interesting.
Yes.
That there is an article in the materials before you, and I'm just trying to remember which one it is. Perhaps Mr. Russell can assist later, in which the DIFC trust law is analysed, and there's a section in that article on reserved powers of trustees, and the manner in which the DIFC law is quite generous, deliberately so, in that regard, and that's to reflect exactly the Islamic context of this region. If a settler, of course, the first answer to your concern is that if you were a wise settler in the first place, you would devise your settlement in a way that respected Sharia, and so your intentions would be fully reflected, and then the trust can give effect to that. If to the extent that by accident or otherwise the settler wished to alter the terms of the trust, then it must be done consistent with the law, and it is not possible to simply rewrite it. There are constraints on that, and they're set out in the law.
Okay. Noted. Thank you very much.
So question 9, I just repeat again, I think for all of us, question 9, and I don't think there's any getting away from it, in that it does require perhaps an elaborate answer, but we hope that the court will be able to rely on the concrete propositions that we've made as certain enough to allow it to assist the practitioners and indeed the families in this area wishing to create these types of trust. So turning then to question 10, I think Justice French raised the question as to whether enforcement, even though the question is very easily answered in one way, he's saying, well, look, why should we give an answer which would suggest that all trusts would be enforceable in all cases? For example, the execution judge on foot of a DIFC court order in onshore Dubai might say, well, look, this raises a question of public policy under UAE law. And of course, yes, but nonetheless, in terms of a strict proposition, the ordinary enforcement provisions of the judicial authority law apply equally in this context.
That is one more thing that is bothering me, you know. We don't have to go too far away. Even within UAE itself, there's a lot of jealousy between the IFC and Dubai onshore courts. You know, and somebody is going to the Dubai onshore courts and start challenging our decision, or rather saying that that is no good as far as the land in Dubai court, Dubai is concerned. That piece of land, the property in Dubai, we are not going to apply that trust law because we don't agree or whatever it is. It's already been happening. And there is another concern, you know. Yes,
of course. But you are the Court of Appeal of the DIFC court.
I know, but Dubai is not obligated. Dubai is not obligated to listen to us or to follow us.
But if
Dubai court is not obligated to follow us.
But your function, in legal terms, under the jurisdiction here is I think to answer the questions if you're comfortable with doing so in the exercise of your discretion and assisting. And what you say positively to the world as the Court of Appeal of the DIFC will have a reverberation and is designed to comfort and assist.
I think so.
Well,
because I put here, how would the court, why are you so confident, I use the word confident, that the regional courts will be influenced by our decision?
Well, maybe I'm an optimist.
You know,
but
there's
I think
been going on a lot of jealousy between
maybe they didn't have to.
Courts. There's a lot. Yeah, go on, Judge Ali.
Chief Justice, maybe they didn't have to. I think what Mr. Mellon was to refer to that this court, I mean, the urge is that this court make our decision in regard of a trust enforceable and goes smoothly through the pipeline to the enforcement outside, whether to Dubai court or to the federal system, or maybe to the wider, like through the GCC convention to our board. So what we can control is that the authoritative decisions goes for enforcement from our side as any other authoritative judgment that's enforceable usually. So you can't control the far end. You can't have your saying, and you can't put yourself in the shoes of other court. Yes, they might disagree with you for any mean, like between Dubai local court and DFC has a huge gap when it's come to the legal culture, legal doctrine. Yes, it's I would spare saying maybe a jealousy, but it's really there are a huge difference when it's come to the culture.
Yes,
they look at
I agree with you, Judge Ali. I agree with you. I'm disagreeing with Patrick and Mr. Russell. That's what I'm saying.
I think all of us in one loop, I guess.
Well, I thank you very much.
Let's go on. Anyway, don't worry about it. We'll make our decision and see what happens after this.
Maybe I could just end with one happy note of optimism, which is to say that in my experience as a lawyer, the appellate judgments are one of the ways in which legal cultures are strongly influenced and where future paths and developments are highlighted. And this is an opportunity to do so. And you as the Court of Appeal of the DIFC will be listened to, I have no doubt. And you are the authoritative body to interpret these laws.
Okay, I'm very happy to hear that. I'm sure we are happy to hear that. Thank you.
Thank you.
So your next question is question 11.
Question 11. This question is one that we as a submitter provided some statutory qualification to, but it doesn't really impact upon the answer. And we would say that there are general constraints that may operate on the ability of a company to act as a trustee in DIFC law, and there are also duties of any trust company that we'd have to comply with the regulatory law. But subject to that, we believe, in common with our other submitters, that this actually can be quite an important point in practice. Private trust companies are increasingly part of the tools and landscape mechanisms available for sustainable wealth management, and they are being considered and applied and put into practice across the region, and therefore a simple answer from this court may allay some of the hesitations in the wider legal community as to whether these instruments are compatible, that a settlor may, through that private trust company, continue to exercise influence over the inter vivos dispositions while the settlor is alive. And in the context of Islamic families, that is, as I understand, I think that's quite an important practical question. And again, even though it may seem like an obvious answer, something from this court to endorse the general facility for a settler to do that would have a practical reverberation.
You know what's missing from here is, except for Judge Ali, we don't have the benefit of hearing, and maybe that's why Judge Ali asked whether Mr. Hamade is an expert, a legal jurist in Sharia law. We don't have that privilege of hearing what the Sharia lawyer would say. You know, we have been hearing from the common law side, yes, but what would a Sharia lawyer say? You know, that's part we are missing here. You know, we can tell what the law is, what we think the English law is or the common law is, but how would Sharia decide whether, say, for example, provision of prevents a settlor from a trust from a shareholder? How does a Sharia lawyer view a shareholder or view a director of a company? You know, I do not know. I know that part of it.
Yeah.
So that's something we have to consider too.
Of course, Chief Justice.
Okay.
Yes.
Okay, thank you.
The question 12, I'll be very quick. We were concerned in our answer to this to just emphasize that if and to the extent that a trust was being set aside or varied, that the answer in this context, that in the Sharia law context, background context, that the key question and the key focus is the intention of the settler and the coherence of the trust. And it's not that one would not be exercising this jurisdiction to give effect to Sharia law or to give effect to any overriding or conflicting principle of Sharia law. It is the trust instrument and the intention of the settlor that is given effect to, and that gives rise to the need for a variation or a provision being set aside, or indeed the trust itself being set aside. And then the final question in relation to public policy. Again, the statutory scheme of the trust law and the statutory scheme of the foundations law doesn't really in itself give rise to any public policy issue. The public policy of the DIFC, as it's articulated in these statutory schemes, quite clearly in putting in force firewall provisions, in expressly ring fencing the operation of DIFC law and how it must independently be interpreted and applied independently of Sharia law principles, gives the answer that as a matter of statutory interpretation, as a matter of construction, these statutory schemes do not give rise to any public policy issue insofar as Sharia law applies. So I think that is the perspective on this question.
Well, Mr. Miller, if you bear with me a little bit, I mean, when we talk about public policy, I mean, it should not be as wide as that. It should be public policy in respect of certain things. And if we're talking about transformation of anything related to Sharia, even within the DFC, or if it's organized or let's say regulated by maybe federal or another law. So it's a matter sometimes of a higher regulatory scheme. Then the source of that public policy would vary. Maybe it would not necessarily be limited to the DIFC, but it might be something else. And I think it would be, in my opinion for now, it might be a very harsh statement to say the policy within the DIFC, I mean, with the source of the DIFC trust law itself. So
yes,
it could be wider. The public policy could be wider because the source might really differ.
Yes, and it is a very interesting question. And I suppose I've given the primary answer. I mean, for example, if you look at the very influential beginning of the first couple of paragraphs of Winfield's article on public policy. It's from 1928. It's still an excellent summary. But public policy comes from different sources. Of course, it comes from the Constitution. It comes from statutory provisions, etc. I suppose I've given the first answer. The first answer is the statutory schemes themselves provide a coherent and express ring fencing of how external operation of Sharia elsewhere does not impact here. But then, as you say, Justice Ali, there is a second aspect to the question. As Justice Al-Sawalehi stated in the Bean, I call it the Bean case, it was a case in which I appeared, DIFC, the public policy of the DIFC is part and parcel of and influenced by the public policy of the UAE. But the public policy of the UAE, in so far as it is applied in the DIFC, may in fact be different. So what you have from Justice Sawalehi is a very interesting idea that even if the statutory language here were the public policy of the UAE, you could still say that that's not unitary. That's not the same in every part of the UAE. In the DIFC, because the DIFC is given effect to certain provisions and statute, obviously public policy is different here than it is in Dubai, than it is in Ajman or Abu Dhabi. And that's very interesting. And I think the question which David Russell and I discussed yesterday, we didn't have a complete answer to it by any means, is does that mean that in this context, the wider federal law, the constitution of the UAE, the other statutory contexts of the other emirates ought not to come in and influence the identification of public policy here in the DIFC? And I think probably Justice Al-Sawalehi's judgment hints at that, at least from the perspective of public policy of the UAE, but equally you could apply the same analysis to public policy of the DIFC. It's part of something greater. But having said that, I think for all the reasons we've discussed about recognition of trusts and how they operate here in this region, and in this country, there is in existence a statutory reconciliation of those differences, to the extent that differences of public policy exist between the UAE, or between, say, Abu Dhabi and Dubai and the DIFC. There has been a legislative solution to that. And therefore, quite clearly, in terms of the narrow question asked by 13, there could clearly be no public policy issue for somebody whose intentions and whose religious obligations are never likely to give rise to any question of Sharia law from creating a trust that conflicts with Sharia law. And in my view is that DIFC law is in fact overtly neutral on this inheritance question, and that as a matter of DIFC law, a conflict with Sharia law does not give rise to any invalidity of a trust or of a foundation, and that the way in which the consequences of that may impact outside the DIFC is a matter for other laws.
Again, this is Sharia law, Islamic law. A Muslim can leave his property for the benefit of a non-Muslim, right, Judge Ali? Am I right there? By way of waqaf. That's how I understand.
Right.
Am I right there, Judge Ali? I can't hear you. Sorry, I can't hear you.
I said yes, in a form of waqaf, yes, as there is many different forms of waqaf, but one of them, yes, a non-Muslim can benefit from a Muslim waqf, yes.
In certain circumstances, maybe. So this question, there is no yes or no answer. It depends also on what the Islamic principles are. If it is against the Islamic principles, of course it is against the public policy in the IFC.
Yeah. I think
no doubt about that.
Yes, Chief Justice. I think the starting point, the starting point for question 13 is that there would be a conflict. So I'm assuming, because I think the starting assumption of question 13 is if there were a conflict, would it give rise to any public policy issue?
If there's no conflict, of course, it may not be, I don't know.
For clarity, CJ, I mean, even the decision of this court, I mean, by confirming the question of brought by DEFCA, I mean, any affected person from this interpretation might take our decision before the Union Supreme Court for a constitutionality check as well.
Yes,
so they might say this is invalid. So at the end of the day, I said there is room, even there is a higher authority, which is the Union Supreme Court. If our interpretation might conflict in favor of another jurisdiction, so the Union Supreme Court might have a saying about the finding of this court.
If I'm a beneficiary there, and then there's a non-Muslim beneficiary, I may challenge it, Or as I said just now, they want to go to Dubai and enforce some order in the Dubai court because it involves an asset in the Dubai court. Then they can challenge at the Dubai courts. Then question of public policy is only public policy within the IFC.
I think that the answer, that challenge would be public policy of the UAE as applied in the particular emirate. But the answer that your question is public policy of the DIFC.
Because the question says the IFC.
Yeah, that's right. And that's because that reflects the statutory language. It is the case in, for example, the arbitration cases, as I understand, that the freedom to challenge public policy in an onshore emirate, even if a public policy issue was raised in the DIFC case, in an enforcement context, you would still have that freedom. And that is the same here. I agree that somebody in an enforcement context may decide to raise an issue of UAE public policy, and that would involve principles of Sharia. But in terms of the answer to the DIFC public policy, as I say, DIFC law in our respectful submission is neutral, and it treats the primary question is the intention of the settler.
I foresee whatever decision we make maybe may contain a lot of caveats and conditions. I don't know. I've not discussed with my other judges, but there's a lot of ifs and what happened if this happened, So okay.
Yes.
Is there anybody else who wants to address us?
Thank you.
Anybody present in the court who wants to address us?
Yes, this is Fadi Hamadi on the line. I would like just to...
Mr. Hamadi? Hamadi, yes, Mr. Hamadi.
Yes, I would like to add a few words, Your Honor, and thank you and the court for listening to us today. Very, very briefly, I see there's a lot of uncertainty, really, on the overlap between the IFC and the onshore jurisdictions, mainly regarding the Sharia and what Sharia is. And this is not a uncertainty that is going to be resolved today. I'm certain, as you are. I think the way I look at it is that the IFC wealth management structure is at serious disadvantage going forward, simply because the onshore jurisdiction now are moving towards passing laws that by nature of them are considered to be more Sharia friendly just because they're issued in an onshore jurisdiction. And so, you know, there is a law that was issued in 2018 called the Federal Waqf Law number 5, which I think is a formidable law, notwithstanding the advice of Al-Tamimi or the lack of enthusiasm about it. I think it's a formidable law, and I had a hand in drafting it. And if a trust law is going to be issued soon, then it will be, unfortunately for the wealth management system in the IFC, be considered as Sharia compliant just because it was issued by the federal authorities. I think what is important for the court to realize today that unless the court manages to alleviate the concerns of interested parties that laws issued in the IFC, namely the trust law as an offshore jurisdiction and foundation law, are not just because they are issued in the IFC, they're not inherently contradictory to the Sharia. And namely, I mean, Sharia is a very broad perspective. The fara'id, the forced heirship rules in the person status law, then I fear for the wealth management system in the IFC is going to be at a serious disadvantage vis-a-vis what is going to be, what is already available by way of legal solutions within the UAE itself. So, yeah, at the end of the day, I believe it's your call, it's the court's call. But from the perspective of someone who's been watching this space for a number of years, I think it will be really a shame after all this effort that family businesses in this part of the world feel themselves naturally sort of disinclined to use what the IFC has to offer simply because there's no assurance that whatever solution they adopt may not be perceived in the future as not being compliant with Sharia. So a simple statement by the court in this regard, to my mind, will go a long way alleviating these concerns from a precedent perspective. And of course, Your Honor, you should not be worried about what others do. It's not your job in the IFC. I think we should be worried about what we know in the IFC. And what we know is that the laws in the IFC should be firewalled and should give an unrestricted protection to those who opt to benefit from them, that they will not be challenged in the future by any other court outside of the IFC on the basis that they're not Sharia compliant. whether it's a trust or a foundation.
Mr. Hamadi, you would agree that in terms of value of assets, the amount of asset in the DIFC, just take real property. The value of real property outside the DIFC is many times more than what is in the DIFC. I cannot speak for other assets like money. Maybe there's more money in the DIFC than outside the DIFC. But if we make some decision, okay, they follow us, they followed our decision and set up foundations and whatever it is. And then when it comes to enforcing it in Dubai courts, they fail to do so for some reason, because as we discussed at length, whether the law there is different, whether the policy there is different, then your intention of enabling families to create waqafs or trusts may still be defeated. I'm not saying that we should not try. I mean, you want us to decide, we will decide. But you cannot deny that there will be challenges, and there's nothing short of a legislation by UAE itself or by the different emirates of the UAE to make this your plans, your whatever you know, to continue the family business successful. You know, but we'll do what we can do. And second, another one I want to mention to you.
Yes.
Just Ali and I are Muslims, and we cannot avoid, because our duty is interpret common law. We will interpret common law, but we cannot deny that at the back of our minds, the Sharia, the Islamic law is still there for us to bear in mind. You know, so that this is why I raise all these possibilities. You know, but we will decide according to common law of Dubai. Sorry, common law of the IFC. We will decide according to that. But at the back of mind, there is still this question of.
Yeah.
Yeah.
If I may comment on the 2 points you've made, fully agree with you that the wider concern is not going to be mitigated just by the court interpreting in the manner that has been suggested. However, the solution is simple. But what we advising family businesses, what we are doing, clearly we cannot put all our assets in the IFC, but what we can do is to create a holding company that is incorporated in the IFC. And that holding company in turn will own everything outside of the IFC. And the shares of that holding company will form the subject matter of the trust property of the foundation's assets. So to this extent, much of that concern could be alleviated by structuring the trust or the foundation in such manner. As to the fact, you know, I too am Muslim, and at the end of the day, even Islam, there's nothing to say that a waqf cannot be created. The Waqf Law number 5 for 2018 has not said anything about the fact that waqf cannot be created in a manner that is not entirely consistent with fara'id. A waqif or settler could, for instance, decide that a female and a male, his son and his daughter, will get the same participation quota as beneficiaries, and that would not be considered as violating Sharia. The same cannot be said. That's the whole argument about a similar text in a trust deed, simply because of that natural apprehension about trust not being Sharia compliant. And this is why I feel it's a bit of a disadvantage for trust and foundation law that requires a bit of an extra effort to clarify that, yes, we believe as legislators, as court, that it is consistent with equity, it's consistent with Sharia from our perspective. Now, A court inland may decide otherwise, but as far as we're concerned, at this side of the fence, we would have done everything we can to alleviate the concerns of practitioners, knowing very well, Your Honor, that no effort is going to be seamless or perfect. And as you rightly said at the beginning, only time can tell us whether more precedents will come to the attention of court and more precisions and clarifications would require to be done in the future.
Okay, we realize we bear that in mind. Thank you very much, Mr. Hamadi. Is there anything else you want to say? Nothing? Okay, Mr. Hamadi. Do you want, is there anybody else want to say, address us? That's all?
If I may, Chief Justice, it's Alistair Glover here. I won't take up much of the court's time at all, but having listened intently and very interestedly, I'd just like to sort of explain very briefly the interest of STEP Arabia. So as I mentioned at the outset, STEP is the Society of Trusts and Estate Practitioners, essentially an industry professional body representing primarily lawyers, accountants, and fiduciaries in wealth management broadly and private client work. Within STEP is a global organisation and has tens of thousands of members. Within that network, there is a branch based out of Dubai, STEP Arabia, which looks at private client issues and obviously laws relating to the private client structuring world in the context particularly of regional planning. And part of our role is to educate our members, to support the frameworks and other institutions that there may be a dialogue with. So today is a classic example of that. And one of the areas that I think it's fair to say that, you know, ever since the DIFC came into being, that has been of great interest to STEP and its members has been the DIFC trust law, having been around since 2005, and then obviously updated in 2018, and the development of the foundations law. And along the way, you know, these are fantastic laws on paper, and I think most of our membership can see the benefit to themselves in servicing their clients, but they are largely untapped still. We're starting to see more take up of DIFC structures, but I think a lot of the concerns that you have about the interplay between DIFC and the onshore jurisdiction is absolutely right. But I would agree with Mr. Hamadeh that, you know, what we would like to see is anything that the DIFC courts, so yourselves, can do to provide greater certainty in terms of the interpretation of its own laws, particularly. That is going to be helpful. It will be very helpful to our members. It's a constant issue that comes up and is raised by our members at conferences and presentations, that we have these fantastic laws, but there's always a big but. But, you know, does this work? How would this be interpreted in the DIFC court? And as a jurisdiction that's relatively new, it's got a long way to go to compete with established offshore jurisdictions, as you'll know, you know, Jersey, Cayman, BVI, wherever it might be. And so, you know, on behalf of STEP, you know, you taking these questions into consideration as you are is greatly valued in itself, and anything that you can do to lay down authority on these matters, I think will be hugely helpful, and it will be significant.
Okay, thank you very much, Alistair. Is that all? Is there anybody else? Nobody?
Chief Justice, if I might have a short opportunity to reply to what's been said.
Sure. Mr. David, you'll have the last say. I'm just finding out whether there's anybody else who wants to address us. I will allow you to have the last word. Yeah, if there's nobody else, then yeah, Mr. Russell.
Thank you, Your Honour. Your Honour, the Chief, I'm just going to respond briefly to the points that have been made in order, but I will take Your Honour, the Chief Justice's question first, which is relates to the interaction between the decisions in the DIFC and decisions elsewhere. It's relevant to point out to Your Honour that these matters have been addressed in laws outside the DIFC. The first is in the Dubai Endowment Law, which in Article 52 provides that the decisions of or the structures in the DIFC will be recognised. Your Honours will find that at page 782 of the bundle. It is page. It's law number 25.
Yes.
And Your Honour will see at page 782 that there is in Article 52 specific reference to the endowment laws of the DIFC, and it says in terms that that nothing in the Dubai Endowments Law will prejudice the applicable endowment provisions of the DIFC or the jurisdiction of the DIFC courts on the endowments registered therein. So we would say, and this comes back to the public policy issue as well, that at Dubai level there's express recognition that the DIFC courts have, as indeed the Judicial Authority Law says, exclusive jurisdiction in relation to matters arising in relation to DIFC trusts and foundations. The position.
Can you assist me, Mr. Russell, on the question of conflict of laws? English conflict of laws. How would the Dubai court applying English common law react to endowment established outside, say in Dubai, and coming to the IFC and wanting to enforce that in the IFC, even though that endowment is not consistent with certain legislations within the IFC? Do you apply the law where the endowment was set up, or do you apply the law in the IFC? I'm trying to see the reverse so that I can sort of guess what the onshore courts will also, how they will also react to us.
The issue doesn't arise in relation to a trust, because a trust at the moment can't be established in onshore Dubai. I'll come to the federal trust law in a minute.
The trust cannot be established in onshore Dubai?
Yes, it's a civil law jurisdiction, so it doesn't provide for trusts.
I see, okay.
I'll come to the federal trust law in a minute. But in relation to foundations, Article 52, in the DIFC, what the DIFC courts would say is that a foundation, an endowment established under Dubai law or under any other country, the law of any other country that had provided for incorporated ORCAF, would say that its internal matters are matters for its own constitution, and therefore they would apply the law of the place of incorporation. I can let Your Honour have the authority for that, but in broad terms, it would be recognised as a corporation by virtue of its corporate status in its home jurisdiction, and if once so recognised, the laws of its home jurisdiction would be applied to its internal arrangements. The case even gets to the point in England where the name of the case, I think, is Bumper Developments, and the Commissioner of the Metropolitan Police Service, but I'm trying to recall from memory, and I'll send a reference through, involved a temple in India, which the court in England described as little more than a collection of stones. But because it had under Indian law the status of an incorporated body, it was treated as incorporated for the purposes of English law. So I shall send that case.
That's good. That's good. That's good. Thank you. Yeah. Okay.
So far as Dubai courts are concerned, the Dubai law, as I say, could not be clearer. It's Article 52, and as I've said, it's on page 782 of the bundle.
Yes, thank you.
The position in relation to trusts is a little more complex in the sense we're only dealing with a draft federal law, and it's entirely possible that in due course the people who are concerned with drafting it might change its terms, and indeed the IFC has made submissions about the terms of the draft. There's both, and Justice Al-Madhani will probably benefit from having the draft in Arabic, which is document 15A in our case. Document 15B is the English version, and my impression, although my Arabic is not very good, is that the Arabic has suffered very much from its translation into the English version. You'll find the English version, it's, as I say, document 15B. It commences at page 491AH, but the key provision is Article 2 on the draft, which is on the English language draft is page 491AL, and Article 2.2 says that financial free zones, which includes the DIFC, shall be excluded from the application of this law to the extent that there are legislation regulating the trust provided for in this law. So the intention of the draftsman, as the draft legislation presently stands, is again clearly to recognise that there are two streams of, well, it will in fact be three streams of trust law operating within the United Arab Emirates, one with onshore, and one in each of the financial free zones, because the Abu Dhabi global market trust law arrangements are quite different to the DIFC ones. So we would submit that there is no likely problem. If anything, existing Dubai legislation, and insofar as we're able to tell, foreshadowed federal legislation recognises that the laws of these jurisdictions are separate and can proceed. If I can now turn to the other questions briefly, Your Honour, Justice French asked my colleague Mr. Dylan Malone, SC, whether or not any of the advisory jurisdictions that have been referred to include an advisory jurisdiction in relation to law generally as opposed to constitutional matters. We were certainly able to identify one, which is in India. The jurisdiction extends to any question of law. We've given Your Honour the reference in footnote 6 of our original submissions. It is in fact section 143 of the Indian Constitution. Your Honours will see that we've then identified the constitutional issues, including Malaysia. Of course,
do you have the word? Do you have the wording there, Mr. Russell? Do you have the wording there? Can you just read it to me? What does it say?
The wording of the Indian Constitution.
Article 143. Do you happen to have with you there?
I don't have the wording.
Okay, never mind. That's okay. I'll read it later.
We shall send it to you.
Article 143.
No. Article 143. Yes.
Yes.
Chief Justice, might I just add a point? Excuse me for interrupting, Mr. Russell. I've just remembered we have in Ireland what's called a case-stated procedure, in which lower courts can refer questions of law arising
by way of
in any concrete case by way of case stated.
Yeah, but still they're based on specific facts, isn't it?
Yes.
Okay.
And indeed, under Article 27 of the DIFC court law, there's a jurisdiction in the courts of first instance to do the same. The other question, Your Honour, the Chief Justice asked of my colleague Mr. Dylan Malone was the point about how do you know that everybody who might have an interest in this is here. We listed in the first part of our submissions the details of the notification arrangements that were engaged in by the court or requested by the court in the Deputy Registrar's directions. Following that direction, there was widespread notification within the DIFC, including to every registered law firm. The details of that are set out in Mr. Visser's second affidavit. So if people have, and also what was required was to be listed on the DIFC's website, as it has been. And in fact, the court will be able to verify, it's also fully covered in the court's website, so that everything that could possibly be done to notify to potentially interested parties has been done.
Okay.
On question 2 and the matters relating to the difference between ourselves and Al Tamimi, that's dealt with in our submissions in response. It's paragraphs 12 to 21, and they're on pages 243 and 244 of the hearing bundle. I've been through them in brief in response to Justice French's questions earlier. The propositions don't improve with repetition, and I'm conscious that we're taking up the court's time, so what we have to say is set out there. I think Your Honour the Chief Justice asked what assistance one has on Sharia matters. I've already drawn attention to the submissions by the DIFC's Sharia advisors. That's document 41 of the case of the hearing bundle, commencing at page 1445. Whilst the names of the Islamic experts that appear at towards the end of that document are at page page 1456 of the hearing bundle, are not names that are known to me. I suspect that some, at least, of them will be known to perhaps yourself, because I understand that at least one of them is from Malaysia, and certainly some of them will be known to Justice Madhani. But
I must confess, I wasn't aware of that. 11145. Ayman, can you help me?
1456.
1456. Ayman, can you help me? I just want to see what it covers. What does the opinion cover? 1456. Oh my God. Articles? No. Opinion. I haven't got 1456. 1456. 1456. I haven't got to 1456. I don't have 1456. I've got 1458 or other materials.
CJ, just accept the reference from Ayman. He already sent it.
Okay, you
have sent the reference.
Okay. Where is it? I've not been able to get it. Okay, yes. 1445. Sharia opinion with wealth management report.
And
let me read this.
The names are on page 1456, Your Honour.
Yeah, okay. Let me read this. I don't know how relevant they are to our case. I just want to know whether it's relevant to what we are here to do. Okay.
I mean, it's a review of the...
Mark this for me, Ayman. Mark these pages for me, please.
Yes, of course.
I'll be recalling this data from you. Okay, thank you very much, Mr. Russell.
And and essentially, the court, I think, can have confidence that a great deal of effort was gone into by the DIFC to make sure that there was no conflict with Sharia associated with these proposals. In relation to question 8 and the issue that was raised about a possible inconsistency in relation to a disposition of property outside the DIFC that might be subject to the DIFC trust law and whether that could lead to a conflict. The court's already been referred to paragraph F of the suggested answer that came on the document headed questions and revised proposed answers, which points out that there's explicit provision in the trust law and the foundations law to make it clear that if the disposition of the property which is outside the DIFC is invalid according to in the case of a will, the law of the testator's last domicile, or in the case of a disposition inter vivos, not in accordance with the requirements of the law, then the consequence is that neither the trust law nor the foundations law operates to protect it. So that there's no question of a conflict. That's decided necessarily in accordance with the law where the property is situated if the transferor is still alive, and in accordance with the domicile of the last domicile of the testator in the case of a will, so that the property never gets into the trust or the foundation if it's invalid. So that prospect of conflict doesn't arise. And obviously, in relation to a Muslim holding property in the United Arab Emirates, Sharia principles will be applied by the local courts in relation to that issue. Justice Al-Madhani made the point in relation to question 10, and we would, with respect, repeat it, that question 10 only asks what happens in the DIFC. What happens outside the DIFC is not a matter on which this court can express binding opinions. But the point about question 10 is, as Justice Al-Madhani suggested, to clarify what the position within the DIFC itself is. Once the matter gets to an execution judge in Dubai, the various, or for that matter, under the Riyadh Convention or the GCC Convention, then obviously the local laws will determine whether or not there are applicable exemptions. But this answers the question for within the DIFC and as far as DIFC laws are concerned. The remaining question comes down to, question 11. I think, Your Honour, the Chief Justice was concerned about the position of directors and shareholders of a company which is trustee of a trust. The short answer in our respectful submission is that Sharia says very little about that. Sharia entitlements may fix on shares in a company if somebody who owns them dies. As we apprehend the position, the obligations of a director outside the DIFC are determined by the Commercial Companies Law, and a director has to comply with that. And it's only to the extent that the Commercial Companies Law introduces elements of Sharia that it would be necessary to consider them in that context. Given that incorporated companies were not part of Islamic jurisprudence, or indeed even of common law jurisprudence until the 1850s, we think it unlikely that there would be anything of significance in the Commercial Companies Law which imports Sharia concepts, and the same would apply in the context of companies incorporated in the DIFC. Finally, there was the question of public policy, and here Your Honours effectively have two views, or two options. One is to look at public policy in what I'll call the narrow sense of just looking at the DIFC law itself. The alternative is to look at it in the wider sense of taking into account United Arab Emirates public policy. And our third submission addresses that, having regard to the observations of Justice Al-Sawalahi, which are interesting because he had before him, a bit like Your Honours do today, parties who were furiously in agreement as to what his approach should be, and he thought they were wrong. They both submitted, and the extract is set out at some length in the submissions, that you could ignore UAE public policy altogether, in the sense that the only thing that mattered was public policy of the DIFC. And what Justice Al-Sawalahi said was, no, that's not correct. The proper approach, he thought, was that there was UAE public policy, but because the UAE is a federation, because it expressly provides in its national constitution for the establishment of financial free zones, which can have their own systems of civil and commercial laws, that how exactly that public policy will manifest itself in any particular jurisdiction will differ. And if one thinks about it, that's inevitable in any federation. Your Honour, the Chief Justice will have experience from Malaysia, where perhaps the question has arisen. Yes. We have given you a case in India where the Union Supreme Court held that public policy for the purposes of the Indian contract law, which was a union law, was affected in a particular state of the union by its domestic law. And that seems to us self-evidently to be so. Now, so we have put in submissions on the basis that the court may be attracted to the notion of that wider public policy. And that's why we've extended our submissions to cover the developments in the other emirates and at national level, because we say that if the relevant public policy is wider public policy, one cannot say, for example, that trusts are contrary to national public policy if the national government is currently considering introducing a law which expressly recognises the trust laws of the financial free zones. In the same way, we submit that one can't say that it is contrary to public policy to have a foundation in the DIFC when the foundations law in the DIFC is so very similar, and we've set out in the schedules the precise similarities to the endowments laws in each of Sharjah, which interestingly enough preserves the 1/3 restriction on what you can put into a foundation during your lifetime, and on the one hand, and Dubai and the national law on the other. And as Mr. Hamadi's pointed out, the Dubai endowments law expressly permits equal proportions for daughters and sons, whereas the Farad Air arrangements would not. And in addition to the fact that there are national and emirate level endowment laws which are very similar to the DIFC's endowment law, there is explicit recognition of the DIFC's endowment law in Article 52 of the Dubai endowments law. And we've also drawn to your attention particularly the Bahrain trust law, which is an onshore trust law. It is set out, you have the Bahraini trust law as law number 14 of the document 14 in the bundle, which, if I may say so with respect, is particularly well drafted. And it, again, if there is a problem with Sharia and trusts in principle, one might have assumed that that would have occurred to the Bahraini legislators at the time they introduced it. So we would say that even if it is the view of the court that you can't narrowly say there is a public policy of the DIFC and ignore what's going on outside the DIFC, we would say that if one looks at what's going on outside the DIFC and in the rest of the UAE, and for that matter within the region, we would say it strongly supports the contention that we've made that there's absolutely nothing in public policy which is inconsistent with what the DIFC laws provide. The one final point,
Yes.
on question 13 is that, because Justice Madhani asked about its impact in terms of Muslims, question 13 is expressly asked in relation to people who are not and who have never been Muslims. Your Honour, the Chief Justice will recall that expression because it appears in the jurisdiction of the Wills and Probate Registry. And the whole point to make there was that whatever the position may be in relation to a Muslim, there is nothing in UAE law or Dubai law which limits testamentary disposition for people who are non-Muslims. And indeed, and we've given a reference to it in our submissions, there's an express provision in, I think it's the law of personal status, but it's certainly one of the laws we've quoted, which gives to a non-Muslim or to a non-national of the UAE the right to adopt the law of his national jurisdiction in relation to his personal affairs. Subject to that, and any questions which the court may have, those are our submissions.
Okay. Mr. Justice French, are you still around? I don't see you.
I'm here. Can you hear me?
Yeah, I can hear you. So you have not missed anything that was going on just now for the last half an hour? I can't see your picture.
No, at one stage, pre-break, we froze for a moment. I lost you, but we got back on. Yeah.
Okay. Do you have any question for anybody who has just spoken?
No. Very helpful submission. Thank you.
Thank you. Judge Ali, any question?
Thank
to
you.
anybody?
No further questions.
Okay, it's
Chief
6:05
Justice,
p.m.
apologies
Malaysian
for
time.
interrupting.
Yes.
I just have the reference that I missed earlier. Apologies.
Okay, what's that?
It's the article I mentioned that discusses the reserved powers. Is the De La Rosa article starting at 2562, and the section starts at 2569.
Okay, 2562. Okay, noted. Thank you very much. So is what is it now? It's 6:05. It's about 2:05 p.m. your time, Ali. Judge Ali. You are 2 p.m. now. 10 past 2.
That's right. Yes.
We are here 6 p.m. We are ready to go to bed.
Good night then.
Okay. I would like to say thank you very much to all who have addressed us. They're very, very useful indeed. But I think Judge French and Ali will agree with me that we want to reserve in case we need some clarification, we might invite you come back here, not today, maybe next week or whatever it is when we are writing our judgments. We may find we may need some clarification. We may invite you to address us again. I just want to reserve that. But otherwise, for now, I want to say thank you very much to you all. I think with your very enlightening submissions, it has, I think, made our life will make our life a bit easier trying to write this judgment, But still, I foresee a lot of headwinds coming. We will try to do our best to fit in with whatever you wish. So with that, thank you very much. Good pleasant day. You still got half a day to go. I don't have very much, and Judge French and I don't have very much left of the day. So for Judge French